Also, my lord, item number 10 on behalf of CC Doctor, my lord, he has some difficulty. Can we pass over the day? Item 10. It can be on Monday or any day. You will also come.
Listed 8/6/2026 as paid for by Mr. R.P. Sharma and his senior counsel, appearing on behalf of Mr. S. Datta and his senior counsel for the petitioner.
May please, your Lord. Let's document from item number 17. I have taken consent from the caveator side, Lord. Item number 17.
When do you want?
After 1
List after a week as paid for by counsel for the
petitioner.
petitioner.
Obliged, Lord.
My lord, regarding item 47, my lord, supplementary or my lord. Worship, this item last occasion also could not. It is a restoration matter, Worship. RSA was dismissed for default.
Okay, we'll take it up.
I am also maybe taken up at 2, my lord.
We'll take it up. Don't worry.
Oh, no, not sure.
And we are not saying, but we'll take it up.
May please, your Lordship. I beg to mention item number 7, Lordship, with consent of others at Lordship. Meta may adjourn for a day, Lordship. Next week.
We are for?
Petitioner, Lordship.
Okay, with consent on the other side. The land counsel for the petitioner place for adjournment, where is allowed.
Interim may continue.
List on?
Next week, in
List on 10/7, 10/6. Entry matter passed list and extended to the next day of this one.
May please, your Lordship. May I for listing of a transfer petition next week, Lordship.
Next.
But we can consent to the outside documents. I remember I worked today's list here. I've taken consent. I am not feeling well since last night. Maybe after 2 weeks, I am for the responding.
Okay, with consent on the other side, the land counsel for the respondent number 1 place for adjournment. List after
2 weeks.
Is there an entry there?
Interim is the not till today. It is itself
Achha.
until further.
Okay. List after 2 weeks.
Much.
May I please, your lordship? Lordship, I beg for listing of one transfer petition, lordship.
Listing, give it there.
Lordship, I beg to mention item number 12, my lord. My lord, I may be allowed to withdraw the matter, my lord.
Okay.
I think 12.
For instructions, Mr.
M.H. Soikan.
M.H. Saikal and counsel for the petitioner. Please to allow the petitioner to withdraw his application. Here is allowed. I can dismiss on withdrawal. Just check it. Make a note. If there's an entry, it will be recorded. Okay.
Obliged. Lordship, may I beg to mention item 30.
30.
Learned counsel Mr. Panjam Surana is through VC.
May it please your Lordship?
Yes.
Lordship, I am Pancham Surana. I am representing the petitioner, and we have taken no objection from the other side, my lords. The matter may be kindly accommodated subject to my lord's convenience for 2 weeks, and the interim order may be continued, which has been continuing, my lords. So, due to a personal difficulty, I am not able to appear today before my lords.
No, in fact, we don't need the appearance, and according to the what do you call new notification, you can always appear through video conferencing. There's no issue with that.
Yeah, so maybe a week's time may kindly be accorded to my lord, subject to my lord's convenience.
Okay, with consent of the other side, the land counsel for the petitioner placed for adjournment. There is allowed. List again on. Till 6/2026.
The interim order may kindly be continued till then, my lords.
Entry order passed list and extended till the next day of this time.
Deeply grateful, my lords.
Obliged.
Deeply grateful.
Item number 48, my lord. I want to withdraw the, my lord, application on RSA matter. Supplementary.
You want to withdraw this?
My lord.
Okay. Upon instructions, Mr. H.R. Ahmed, counsel for the applicant, is need to withdraw the application. So there is allowed the matter stand dismissed on withdrawal. The RSA will also go then. Yes, ma'am. So consequently, the unregistered RSA under filing number 10756/2025 shall also stand dismissed on withdrawal.
Obliged.
May I please, my lord? My lord, I'm praying for one correction in an order, my lord. On 3/6/26, my lord, I have passed an order wherein there is a mention about the title exhibition piece, my lord. Instead of 2024, my lord, it should be 25. There is a typographical error, my lord. Obliged.
Top of the list, item 1.
Measures, my lord. I have just gone through the, my lord, office note. The
20.
the respondent 7 in this petition was one of the plaintiffs that expired. And the notice came unserved. So my lord, otherwise this matter could be disposed of. But I think that this has to be substituted matter.
Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. D. Dole, Learned Counsel for the petitioner, submit that as per the office note dated 27/5/2026,
Respondent 7, madam, Bidoi Devi.
the process, as per process service report, as per process service report returned, the respondent number 7 has expired, so we place for some time to take appropriate steps. Matter stands adjourned today. None appears for the respondents. Number 1 to 6.
No, Mr. P.N. Sharma appears for some else.
You're appearing for?
12 to 16.
No, these are.
Performa.
Okay, now I can call for respondent numbers 1 to 6 and 9 to 11. Mr. P.N. Sharma, Learned Counsel. For respondent numbers 12 to 16 are present. Next, as per the process service report indicated in the office note dated 27/5/2026, the notice was served on respondent number 8. So none appears on call for this respondent. Next, matter stands adjourned today. Taking note of the fact that by an interim order passed on (28/5/2024), the proceedings of TX case number 40 of 2022 has been paid. If the steps is required to be taken within a week. This from 17/6/2026. Who is that? Who is respondent number 7?
Bidoi Devi.
No. In the decree, is the decree holder.
Yes.
Okay. The log for respondent was 1 to 6 and 8 to 11. This says Sahu is not there.
He got appointment, man, as PP or RSVP in posted, got posted in Mankacha.
Okay, distinct on 17th of June.
17.
6 steps by then.
In the meantime, I'll get the filing. The interim order may continue.
Interim order passed here, stands extended to the visit of the state.
June, my lord. 17 June.
Yes. Next item.
Top of the list, item 2.
Yes, Your Lordship. Your Lordship, kindly the matter may be taken up after some time, Lordship.
Top of the list, item 3.
Means user also Lordship, in this matter we have taken steps, the Lordship.
So you have not taken steps.
Lordship, we are today taking steps, Lordship.
The General Counsel for the petitioner undertakes to take steps for service of notice on the respondents by 6/6/2026. Next, it is made clear that if the petitioner fails to take steps for service of notice by finding the requisites by 6/6/2026, or the interim order passed on 27/8/2025 shall stand vacated without any further reference to the court. Full stop. However, if the steps are taken, the interim order would continue till the next date of listing. Next, notice on the respondents, if taken, is made returnable on the date after vacation. List on so and so. So if you don't take steps by tomorrow, the interim order would be vacated. The interim order would continue only if you take steps.
But today we are taking steps.
Whatever be given time till tomorrow.
Okay. Okay.
Item 4.
Madam, respondent number 1, and the remaining respondents are performed, they are names to start off, my lord.
Yes. What is the matter?
Matter passable for typing and not
Time being. Okay.
Item 6.
For official dated 27/5/2026, the respondent number 1 and 2 appeared. Regarding 3 and 5, address is left, and 6 is unclaimed. And in respect of respondent number 6 and 7, neither ID card nor unserved notice.
What is the order under challenge?
Impugned order is at page 102.
And where is the decree?
It is an ex parte order. Compromise. Page 70.
70.
70.
And what is the plaint?
Plaint is at page 20.
Because only we'll have to interfere with this Champion order.
That's it.
You have admitted that the defendant number 5 and 6, they did not receive the summons. For them, the summons was received by the defendant numbers 1 to 4.
Yes. The record of report is also there.
Therefore,
Yes.
the notice was not served there, and he says that he doesn't reside there.
Yes.
So
In
that
fact-
there is no denial.
In fact, some disputes were also going on between the legal years. I have annexed the suit of 2023 at page 33. Page 33, it is a title suit 27 of 2023. Narendra Paul is the petitioner herein.
Page number?
Page 33. The defendant number 1, Rebarani Paul was his mother, and Goparani Paul, the person who received the notice on behalf of the petitioner, is the defendant number 2, page 34. There were some disputes between the legal years. Then and the same person has received the notice on behalf of the petitioner. In the trial court, the petitioner filed an application under Order 9, Rule 13.
And what is the order?
That's it.
Have you agreed by the order?
I am challenging this order. The petitioner had filed this petition. This order 21, Rule 26 was filed by the petitioner.
Petitioner is that Narendra Paul.
Narendra Paul.
You are for them, him.
I am for?
You are for this Narendra Paul.
Yes.
And who is the decree holder? You are, Mr.
I
You
am
are the decree holder.
Yes, sir.
So the decree holder in this objection at page 95,
Page?
page 95.
Yes.
That is your objection.
Yes.
Because here you have admitted that defendant number 1 to 4 conclusively accepted the notice and appeared. This decree cannot be, will not be sustained.
In fact, in the joint compromise application also, as page 64, it starts at page 33. Yeah, sorry, page 63. This application was filed by the respondents herein. And here also at page 64, paragraph 4. After the death of the mother of the defendants, as the defendant had in fight amongst each other, for which the parties could not. There was a fight between them, the legalians, and by filing this application under Order 21, Rule 26, the petitioner only prayed that till disposal of the Order 9, Rule 13 application, this title execution number 8 of 2025.
It has to be heard, Mr. Viswas.
My lord.
What has happened till now?
My lord, the execution case is pending.
And order 627, because this matter is pending here for some time. What has happened in the meantime?
In the execution is stayed.
No. In your order 9 to 13, what has happened?
For cross-examination of the PW, it is fixed today.
It's fixed today.
Today.
Let Mr. Viswas, we close this matter by relegating both of you to the civil judge senior division. Until this order 9 to 13 is not disposed of, the execution proceeding will have to be stayed. No point keeping this matter pending here. So same thing is happening even while this stay is operating.
Yes.
Order 7 to 13 is proceeding and this is stayed.
Yes.
Let it go there. Mr. D. Chaudhary, Government Counsel for the petitioner, also heard Mr. S. Biswas, Government Counsel appearing for the order number
1 and 2.
1 and 2. Next, in view of the order that is proposed to be passed. Issuance of fresh notice on respondent numbers 3 to 7 is dispensed with. Next, the respondent numbers 1 and 2 are the plaintiffs in PS 90 of 2024. In the said suit, the respondent numbers 1 to, respondent numbers 3 to 7. No. 3 to 7 were respondent numbers, were defendant numbers 1 to 5 respectively. Full stop. The petitioner herein was the defendant number 6 in the said suit. Next one. The Government Counsel for the petitioner projects that there is a family dispute between the petitioner and the respondent numbers 327, which would be evident from the contents of the plaint of CS number 27 of 2023 filed by the petitioner, which is annexed to this application as Annexure 3. So we said this was, this is also pending.
Yes.
This should set to this pending for disposal before the court of Government Municip at page 4. Next paragraph. The respondent numbers 1 and 2 had filed TS 90 of 2024 for specific performance of contract to compel the petitioner and the respondent numbers 3 to 7 to sell the suit land and to deliver khas possession thereof. Full stop. It is projected that the notice on behalf of the summons in the suit was received by the was received by the respondent numbers 3 to 7 for themselves and also for the petitioner within bracket defendant number 6. So accordingly, the suit was ordered to proceed ex parte against the petitioner. So, in course of the proceedings, the respondent numbers 1 and 2 and the respondent numbers 3 to
6.
6 by filing petition number 3121 of 2024 under order 23 rule 3 CPC as stated before the learned civil judge within bracket senior division bracket was 24 page 4. The matter was voluntarily compromised between them. Accordingly, on 21/12/2024, on the date on which the petition was filed, joint compromise decree was drawn up with the agreement between the parties marked with the letter letter X. X is inverted commas. Full stop. The resultant decree was put to execution, which was registered as TX case number 8 of 2025. The petitioner projects that on coming to know about the execution proceedings, he had filed an application under order 9 rule 13 for setting aside the ex parte decree. Which was The petitioner along with respondent number 6, no, respondent number 7. Sharda Paul is respondent number
Seven.
The petitioner is the respondent number 7. Jointly filed this order 9 to 30. Joint filed with them. So sir, it's an ex parte decree dated 21/12/2024. Which was registered as misj case number 24 of 2025 in connection with TS number 90 of 2024, which is stated to be pending before the learned civil judge within bracket senior division bracket close at Tejpur. Full stop. Moreover, comma, a separate application was filed by the petitioner under Order 21 Rule 26 read with Section 151 CPC, which was numbered as petition number 150 of the 25 dated 4/4/2025 before the learned civil judge within bracket civil senior division bracket close Tejpur in connection with TX case number 8 of 2025 under Order 21 Rule 26 read with Section 151 CPC for stay of the execution proceedings. The learned civil judge within bracket senior division was from Tejpur in the proceedings of TX case number 8 of 2025 by referring to petition number 150 of 2025 had arrived at a conclusion that BJ case number 120, BJ case number 24 of 2025, filed under Order 9 to 13 CPC, did not furnish a legal basis for stay and accordingly it was observed by the said learned court that this is only an attempt to delay the execution of the decree and therefore held that the statutory requirement for invoking Order 21 Rule 26 remains unfulfilled, and accordingly the execution proceeding was allowed to proceed. And the application under Order 21 Rule 26 CPC, which was registered as MIJ case number 24 of 2025, was rejected. Agreed by the said order dated 18/12/2025, rejecting MIJ case number 24 of 2025 on the present application was filed under Article 227 of the Constitution of India. Next, on a query of the court, the learned counsel for the petitioner submitted that the application under order 9 to 13 no, something is wrong.
Chip.
No, not that. Earlier paragraph, you see the petition filed under order 21 to 26, read with section 151 was rejected. Next, on the query of the court, the learned counsel for the petitioner submitted that the proceedings of Ms. J case number 24 of 2025 is fixed today for cross-examination of the witnesses. Next paragraph. Mr. The learned counsel for the respondents have proposed the pairs made in the essential locality application on the ground that the decree was not a collusive decree, and therefore, as the defendant number, as the petitioner did not appear despite summons, the service of summons, party decree was sustainable. Next paragraph. We proceed to the opinion of the court. The petitioner, the respondent number 7, for reasons assigned in Ms. J case number 24 of 2025, applied for setting aside the ex parte decree. As the merit of the said application is being examined by the learned civil judge within bracket senior division, it was Sonpur Tejpur, this court reference from making any comment thereon, as it would prejudice either side. Next comment. However, we taken note of the fact that the application under order 9 to 13, which is registered as Ms. J case number 24 of 2025, is on board and is proceeding. If the decree is executed in the meantime, the petitioner would suffer greater loss and injury. Which cannot be compensated in terms of money. Moreover, in the event the application stands allowed and the execution and in the execution proceedings, the property is transferred, it will lead to a multiplicity of proceedings. Next, the court is inclined to hold that the interim order dated 18/11/2025 passed by the learned civil judge within bracket senior division, Sonipur, Tejpur, in connection as executing court in connection with title execution case number 8 of 2025 is not legally sustainable. Accordingly, this said order dated 18/11/2025 rejecting petition number 150 of 2025 dated 4/4/2025 filed under order 21 to 26 read with section 151 CPC is hereby set aside. And the said application is restored to the file of the said learned court for a fresh decision after disposal of the application and order for first consideration after the proceedings of BG case number 24 of 2025 is disposed of. Full stop. Next paragraph. As the execution proceedings is likely to cause more irreparable injury to the petitioner, the further proceedings of title execution case number 8 of 2025 pending before the learned civil judge in bracket senior division by person through Tejpur shall continue to remain stayed till the disposal of BG case number 24 of 2025 in connection with TS number 90 of 2025. Next paragraph. The both sides are directed to appear in the proceedings of the said petition number 150 of 2025 as and when proceedings of BG case number 24 of the 2025 is disposed of. Next paragraph. Under the circumstances, the petition stands allowed to be instead of indicated above. Under the circumstances, there should be no order as to post.
Time being item 4.
Yes. Make it also. The suit was for specific performance of contract for sale. I am the defendant. And the suit was decreed for Schedule A. I mean, in Schedule A of the plaint, my lord, only that number 105 has been mentioned. Accordingly, my lord, the decree was also for Schedule A, that number 105. Then, my lord, they filed execution proceeding. In execution proceeding, they added one new that number 26. We filed objection. After that, my lord, they filed an application for amendment of the decree in the executing court. And the court that has been allowed. Against that, I am before your lordship. The impugn order is at page 69, madam.
There is the amendment application. There is the amendment application.
Amendment application is at page, my lord, 63. And this application was not filed by the decree holder, but by their advocate. Madam, page 64 verification. I, Sri A.C. Bora, advocate of the decree holder.
You have a copy of the cadastral map of these two DAG 105 and 26. You have a copy of the map? There is a copy of the agreement.
Agreement copy I have, my lord, but sorry, my lord, I have not annexed it. Yes, sir.
Yes, apply item ID was here.
This dark, new dark 26 has not been mentioned in the schedule, but in the body of the plaint it is
This
there.
is incomplete,
Body of the plaint it is there.
but this is incomplete. You've given us only 3 pages of the agreement.
I can file it, my lord.
You have a copy of that? No.
Agreement, still agreement to copy from.
And where is the impugned order?
Impugned order is page 69, my lord.
59.
So, where I read one here, this again. Okay.
If you have to hold it.
The agreement I have found, my lord. Right, okay. Huh? I can an accurate.
Yes, what do you say?
Not in the body of the plaint, my lord, we have mentioned the, my lord, new dark that is the 26. In para 3 of the, my lord, plaint, my lord. But in the schedule, it is not there. It is not that we have written something, my lord, totally new.
We are allowing this application. This can't be permitted. We will assign reasons in the order. Heard. Mr. K.K. Dey, learned counsel for the petitioner. Also heard Mr.
Uses okay.
P.G. Saikia.
Uses okay.
U.J. Saikia, learned counsel appearing for respondent number 1.
Yes, no one.
So in view of the fact that the agreement for sale dated 9/3/2013, which was in respect of which decree of specific performance was passed, the petitioner and the petitioner and the respondent number one were only the parties. The issuance of notice on the pro forma respondent numbers 2 to 6 is dispensed with in view of the order which is proposed to be passed. Next paragraph. The respondent number one had filed TS number 42 of 2014 before the learned civil judge within bracket senior division bracket close Tensukia, praying for decree of specific performance of contract for execution and registration of deed registration of sale deed in respect of the land, which is more fully described in the agreement for sale dated 9/8/2013. Full stop. It is not in dispute that the schedule of the said land as mentioned in the schedule to the said agreement is as follows. Page 8. Full stop. Accordingly, the learned from the said schedule is also replicated in the schedule A land in the plaint. Full stop. The learned civil judge within bracket senior division bracket Tensukia by judgment and degree dated 26/6/2023 adjudicated the issues involved and decreed the suit in favor of the respondent number one by holding the respondent number one entitled to a decree for specific performance of contract of an agreement for sale dated 9/3/2013 in respect of Schedule A land, semicolon, for permanent injunction against the defendants and pro forma defendants permanently restraining them from transferring the suit land to any person other than the plaintiff and from doing any act prejudicial to the interest of the plaintiff, semicolon. Further ordering that the defendant and the pro forma defendants being the legal heirs of late Chandrika, Chandrika, Chandrika Singh, being the joint owners of the suit land, shall execute and register a sale deed in respect of Schedule A land within a period of 6 months from the date of decree, semicolon. Further ordering that in the event of failure on part of the defendant and pro forma defendants to execute and register the sale deed, or the same shall be executed in accord and registered in accordance with Order 21 to 34 CPC, semicolon. And it was also ordered that the plaintiff would be entitled to the cost of the suit. Next slide. As the sale deed was not executed, comma, an application for execution was filed, which was registered as TX number 3 of 2024. So, in the said execution proceedings, comma, the respondent number one filed petition number 297/25 dated 18/1/2025 I'm wrong. It's petition number 54456/2025 dated 27/1/2025 under section 152 CPC. Amongst others, comma, stating that in paragraph 2 of the plaint, the petitioner had mentioned, the respondent one had mentioned that the plot of land measuring 1600 square feet was covered by tag number 105 within bracket old, bracket closed, 20 oblique 26 within bracket new of PP Pata number 23 within bracket new. Oh, no, Mr. Day,
My lord.
you are in the wrong side now. It is 26 new is the old Act 105. So how you are prejudiced by that?
Prejudice, my lord, that 26 was not mentioned in the plain sheet.
Not required. Let us say by the time the suit is adjudicated, there are 3 or 4 settlement process. Every time the DAG will change.
And that has to be corrected by the,
Not required,
by in the suit.
not
decree.
required, not required. This is not a case where there is a novation of contract under the specific relief act under 26. It's not a case. Only during the pendency of the suit, a new DAG has come up.
That has not been stated in the petition.
Not required.
Yes,
You see, you have a land, Mr. Day.
my lord.
Every time, every 2 or 3 years, do you go to the settlement office to just take out the new DAG number? No. That was the agreement he made, and now there's a new DAG. It's not your case that in the new DAG something more has been added. The land of 1600 feet has become 3200 feet. That's not your case. I have wrongly read that it would amount to a change in the schedule. No, it doesn't amount. Stop. Therefore, it was stated that it was a clerical mistake in not mentioning the new DAG number, which is 26, along with DAG number 105, which is now the old DAG number. To stop. The petitioner filed an objection to the said application, and the learned executing court, by order dated 14/8/2025, passed in TX 3 of 2024. By taking into consideration that in the plaint, there was a mention of the new DAG number 26, comma, took into consideration that the boundaries of the scheduled land would remain the same. And accordingly, the court had taken a view that it appears to the said learned court that the land is the same and new DAG number 26 perhaps might be created, which would be known by the revenue authority. So accordingly, it was ordered that the respondent plaintiff be allowed to register the sale deed in respect of Schedule A land by consulting revenue authority, or if a new DAG number 26 has been created in respect of the Schedule A land. Next paragraph. The learned counsel for the petitioner submitted that the petition would not be maintainable, as instead of the decree holders signing the application, the petition number 456 of the 25 was filed and sworn by and verified by the counsel for the decree holder. So it is also submitted that although the respondent plaintiff was aware of the new DAG as mentioned in the plaint, but no attempt was made to have a degree drawn up in the to show the new DAG in the schedule, and no attempt was made to have the agreement for sale altered. Next paragraph. The legal counsel for the respondent has made his submissions in support of the impugned order. Next paragraph. In this case, there is no dispute to the fact that the agreement for sale that the Bank 2013 was entered. Comma, the schedule of land intended to be said agreement for sale was the correct description of the land. Maybe it is in public domain that in the state of Assam, from time to time, settlement process is being carried out. And there is every likelihood that existing DAG number would be altered to a new one in the new settlement proceeding. And therefore, if the respondent desires that along with the old DAG number 105, from the new DAG number 26, we also added in the degree for showing correct description of the land. Comma, this would not amount to either a novation of the contract or requiring rectification of the instrument within the meaning of section 26 of the Specific Relief Act. First of the insertion of the new DAG number would not change or alter the content of the otherwise valid agreement for sale. There is a 9/3/2013 based on which the decree was drawn up. First off, next, in this case, the learned executive court was not committed in any illegality in entertaining the application under section 150 of the CPC, which was registered as petition number 456/2025. By refusing to amend the judgment and decree, however, giving liberty to the petitioner to, respondent to have the sale deed registered in respect of Schedule A land by consulting the revenue authority. If a new DAG number 26 has been created in respect of Schedule A land, next part. Even otherwise, if there is no amendment to the schedule of the plaint, but it is by way of an independent settlement process by the land revenue staff and of the land revenue authorities. And in place of DAG number 105, a new DAG number 26 is created. Now, the same would not amount the alteration of the schedule of the land in question in this regard. It would be appropriate to refer to the provision of Rule 3 of Order 7 of the CPC, which provides this under Order 7 Rule 3. Yes, okay. Next paragraph. In this case, the schedule of the suit land contains the description of the immovable property can be identified by boundaries and numbers given in the record of settlement public survey. So therefore, if there is a alteration of the survey numbers, it would be permissible for the executing court to insert the correct, updated survey number on the, as per the record of settlement. To stop. It is not the case of the respondent decree holder that there is any alteration of the boundaries of the suit land. So it does not appear that the objection to the application to the amendment application is on the ground that it would increase the landholding from 1,600 square feet to more than what has been decreed, or it could alter the four boundaries as given in the schedule of the plaint and the consequential decree drawn up. Next paragraph, resultantly, the court is of the considered opinion that the learned civil judge within bracket senior division that was Tinsukia has not committed any illegality or perversity in passing the order dated 14/8/2025, thereby permitting the respondent degree holder to register the sale deed in respect of Schedule A land by consulting the revenue authorities if a new DAT number 26 has been created in respect of Schedule A land. Next, accordingly, this application fails and the sale is dismissed. Next, both the interim order passed on 26/9/2025 stands vacated. Next, both the contesting parties before this court to the learned counsel from both sides are directed to appear before the learned civil judge senior division Tinsukia on 24/6/2026 and by producing a certified copy of the order, I wait for further directions that may be passed by the said learned court. Your document here is any
Time being item.
It be your lordship. Lordship, these petitioners are third party in a suit, lordship. The suit was decreed in favor of the judgment debtors. They are also parties here from party number 22 to 26. And the decree holders are respondents from 1 to 21.
who are you in the decree?
We are the original landowners. We were not made party in the suit, and decree was obtained by the decree holder against the judgment debtors. So we filed an application under section 47, order 21, rule 97 before the learned executing court.
Where is the plaint?
complaint I have not annexed the judgment copy, Lordship, annexure 1, page 15.
Do you have a copy of the decree annexed here?
Up to appendix only I have annexed. Decree আছে তোমার
Hmm.
কাছে? তোমার কাছে আছে? Up to appendix I have annexed. Lordship. Page 25, your Lordship will find the relevant portion. Para 11, as held earlier. The plaintiff successfully proved their right title and interest in respect of the suit land. The evidence of the plaintiff shows that the defendants have illegally disposed the plaintiff. Thus, plaintiffs are found entitled to declaration of their right title and interest, and they are also entitled to get khas possession over the suit land by evicting the defendants with men and materials. Further, the defendants are permanently restrained from disturbing the possession of the plaintiffs after they are put into possession. So these findings is against the judgment debtors. We have filed one title suit, and in that title suit, the decree holders appeared and filed their written statement. Then only we came to know that there is a decree against us, against our property, Lordship, that disputed property, not against us. So we have filed a title suit, that is annexure 6, page 55. Our case is that, Lordship, plaintiff's father sold out the land to one Rasamondal, and Rasamondal sold the said plot of land to our predecessor, Abu Bakr Siddiq. And since then, we were in possession. And we have filed this order, section 47 petition before the learned trial court and declaring everything that we were the owner by registered sale deed, but the learned executing court held that as we have not annexed the registered sale deeds, our petition was rejected. The registered sale deeds I have enclosed along with this petition. Annexure 3, Lordship, kindly see page 36. One Moniruddin Sarkar sold the land in favor of Rasamondal. This Moniruddin Sarkar is the predecessor of the plaintiff's decree holder. And next, sale deed, Lordship, page 42. Rasamondal sold that plot of land to Muhammad Abu Bakr Siddiq, and this Abu Bakr Siddiq is our father. So since the execution of this sale deed, that is 16/9/69, this too is a registered sale deed. We were in possession. Hence, we filed this annexure 5, page 49 petition. That the above noted case has been fixed for NO, that the predecessor in interest of the decree holder, Moniruddin Sarkar, has executed a sale deed by number 387 on 25/1/1965 in favor of Rasamondal, alias Rajamondal, in respect of a plot of land measuring 3 bigha 2 katha 9 lesa, that is the decretal land, that thereafter the decretal land, suit land, has been transferred by said Rasamondal, and executing and registered sale deed white number 3423 dated 17/10/1968 in favor of Abu Bakr Siddiq, that is the father of the third party petitioner. That since the date of purchase, the father of the petitioner third party had possessed the suit land, and after his death, the third party has been possessing the suit land, decretal land. That the third party petitioner have every right, title and possession in the scheduled land since the date of purchase, that due to the erosion of river Manas, the original sale deed so and so has been lost, and the home and house of the third party had also been eroded as such could not able to mutated their name in the suit land, decreted land on the basis of registered sale deed so and so. That therefore the third party petitioner have every right title interest in the suit land. That recently on 25/10/2021, the third party petitioner came to know that a suit was filed by the present decree holder against the judgment debtor, which has been decreed by the learned court on 21/12/2020. But Lordship, after and disclosing this fact that there is a registered sale deed in favor of the petitioner, the learned executing court passed an order which is impugned in this case, that is Annexure 9, page 84. And the relevant portion, Lordship, after discussion, page 86. I have gone through the provisions of section 47.
Yes.
Order 21 and Rule 97, 98, 101 and Section 151 of CPC. I have also gone through the petition, written objection and the case record of title suit number so and so.
But the
In
court
this
is right.
instant,
If in that ground it is rejecting it,
rejected only on the ground that in this instant petition, since the
because
third
you
party
don't show the title before the executing court.
Lordship,
You did not show your title before the executing court.
Lordship, that document, number of the documents were mentioned in the petition, but those were not enclosed, Lordship.
Then
Failed to submit any registered sale deed to prove their title over the suit land. Hence, this court has not found any merit in the petition bearing number so and so. Accordingly, this petition is rejected. But Lordship, it is the duty of the executing court to decide the right title of any party if brought in a petition under Order 21 Rule 97 or under Section 47. So if any issues have been framed on that, this is the third party petitioners will certainly prove their right title by exhibiting those documents, Lordship. The court would have called for the documents, Lordship, from the plaintiffs, but there was no chance given only on the basis that those were not annexed with the petition. My petition was rejected. And by this time, Lordship, the plaintiff witnesses were cross-examined in the title suit which was filed by me. Already that suit is pending. And the decree holder are contesting their written statement also I have enclosed in this case. Page 63 at their written statement in title suit case number 80/2021. So only if on the ground that the registered sale deeds were not submitted before the executing court, Lordship. For that, a chance may be given, we will submit a proper application along with all the sale deeds. It's because already there is a title suit pending and the case is proceeding in between decree holder and the present petitioners. So till the decision in the title suit, that execution has to be stopped, Lordship. Otherwise, there will be irreparable loss and.
But again, you suffer a technical defect. If this, if your application under Order 21 Rule 97 is rejected,
Lordship, that will be a decree, Lordship. But Lordship, Section 47 is there, so I have filed.
no. There are judgments, even this court has passed orders, where you have said that even if the application is filed under Section 47, Supreme Court also says so. It has to be treated as one under Order 21 Rule 97 and proceeded.
Deemed decree, Lordship, as because there is a rejection. And in this case, it is true that the petition was rejected on merit, on the ground that we have not enclosed the. As Section 47 was there, so I have filed 227, Lordship. Or Lordship may allow me to withdraw with liberty to approach the appropriate forum, Lordship.
That can be granted. Only a technical error.
Appeal would lie.
Hmm?
An appeal would lie.
It would lie.
Other than that, your lordship, I would just point out one thing as regards the merit of the case, your lordship.
Merit, if you allow us to assume jurisdiction, then we take it up. Then we will say that the consent of the parties matter has been heard.
Lordship, if they withdraw it with the liberty, it's.
You see, it is entitled to a liberty.
That Samir Singh is there, Lordship, and there is a decision of Samir Singh, Lordship, Samir Singh and another versus Abdul Rob and others. It says if, in that case, the executing court says that it has become functus officio, so the application was rejected. Supreme Court says if it says functus officio, then jurisdictional error 115 is applicable, and after amendment, it will be 227, Lordship. That order is not deemed decree, but in other way, if on merit,
That's not said.
yes, Lordship,
They have
in on
exercised-
merit,
The court has exercised jurisdiction. So that's why. This is a judgment which I have not immediately finding it out. I have followed it in one of the matters. It says that application under section 47 shall be considered as one under section
21.
adjudicated under order 21 to 90, 97, 99. That is one part. When Mr. What do you call, Mr. Mukherjee says that this court can pass an order, then we have jurisdiction, because then we will go with on the premises that once a suit is filed, so then order 29, 21 to 90, 21 to 90, 26 would apply. And the second proceeding would have to stop. Because that is otherwise permissible when we interpret that the recent judgment of the Supreme Court in the case of that Ganesh Singh versus Bhartiari. That is by Justice. That is the leading judgment now on the execution, delineating the modalities of order 21 rule 97, and why a separate suit would otherwise be maintainable. So that is the
Ganesh Singh versus Lordship.
Ganesh Singh versus Bhartiari. So that's why I said if I can cover both sides. Just
If
pick up again, come back.
If section 47 is equivalent to order 21 rule 98, then it is decided on merit, then it
No,
will become a decree.
That's why I gave an opportunity to Mr. Mukherjee. If he says that yes, you can still adjudicate, then we have that revenue open. But the only limitation would be to take the second view. Is that once the application is filed under order 21 rule 97, or the section 47 can be treated like one, so that is within limitation, and therefore the other suit would also be maintainable.
In view of section 10, the suit.
The suit, for the suiting, it's not that. The issue is that for order 21 to 99, one should come within the limitation otherwise prescribed. She says that once in that suit, when you file a written statement, then she comes to know about this application. And therefore, this objection which has come is within time. It can't be said to be barred by any law for the timing in force. And therefore, even that suit can proceed.
That suit will proceed.
So then the application would have been, the liberty to the petitioner would have been to file an objection under 21 to 26 for stay of the suit till the issues are decided in the earlier suit. Just they can come back. It took my case parties, case index, yes. Make it search left side, search. Yes. Now. So go by case index. Close this. Case index. Give find by citation. Find by citation. Fourth one. Just type it out one INSC. No, type it out there. INSC. IN. Just set SCC. Yes. First part, yes. No, first part, SCC. Yes. Let me just come on.
It will be available in DGSCR Supreme Court. JB party will not.
2025 SEC online 2805. So this will be SEC online. It will be down below. Oh, quite below. I'm going. I'm going. Keep going down. Go down. SEC online. Go down. Hold down. Scroll down. Go down. Go down. I'm going down.
Two thousand twenty-five INSC 1434 RPS SCC online কত তোমার কাছে বের হয়নি আমার কাছে INSC বের হয়েছে INSC 1434
Yes. Now, paragraph 36. Yes. Getting it there.
Yes.
Usually when third party could file an application on the order 21 was when he could resolve to separate suit. Now, this is being discussed. Then come below to paragraph 38. Clarification scenario 2. Again, 39. Here, public and different use regarding third party can file a suit. Then on housing is referred. Here it says, we only wish to point out the view taken by Square Housing is held to be a correct view, and the interest of justice we demand that third party position obtains knowledge of the confirmation of the sale and which is is right, and the interest in sale must not only be allowed to remedies early come to be disposal, which disposition is an essential increase under 99. Therefore, the option of filing a separate suit must be available to it. The court says that it is not permissible that somebody will be evicted from the land. Then after eviction, we will file a suit. And either under 99 or a separate suit. Then it comes, another view is taken, and then 42 is the issue of dividend. Then 42 of the event on limitation, and then the summary is 247. The review for declaration position for like have been started for the but from nuisance about the provisions we have happened in the then it says the decision in the general das. In this case, the issue was pending, the transfer pending back.
Yes.
So that does not apply here. Yeah. Come down below Roman 8. Two factors down. Yes. Now eight will come. This is one. Yes. So third party under rule 92(4) would be third party under the judgment letter. And is right that was interest by toxic period under T 97 or 99 or 21 respected very simply the third party under now in this case, before that second option is exercised, it is already filed as to. Now, therefore, once it now 12. You see, here the difference is 12. The difference is that the party who was in before the Supreme Court
Were transferred.
derives title to content like
And judgment letter.
therefore he is a representative. But omit that and then read. First, the separate sensitive has also not be maintainable because they are representative of the judgment letter and the bar and still fairly applied. In her case, it does not.
That is why the suit is continuing.
The suit will continue. If the suit continues, then order 21, 26,
26.
26.
Yes.
That applies. So then it would be a jurisdictional error.
Lordship, in another view of the matter, if this court takes it up, it will be troublesome for the petitioners here in your lordship because they may lose a forum, your lordship, if they do not prefer an appeal.
We don't say anything, we just say that we go back to the same court because of the non-consideration of this aspect. It would be a jurisdictional error.
Lordship. Another thing, your lordship, at page 23 of the petition.
23.
23. It is a part of the judgment, your lordship, which is under execution. Starts from page 15, annexure 1. This suit, the present petitioners were not a party. And in this suit, an issue was there, issue number 3 at page 23, whether the predecessors of the plaintiff, that is our predecessors, executed a sale deed number so-and-so, dated so-and-so, and deed number so-and-so in favor of one Rosa Mandal, which they are alleging. So why I say this? Because this is apparently a collusion, your lordship, between the defendants of this suit and the present third-party objectors. The same sale deed, which now the third-party objectors are alleging, your lordship, was taken a ground of defense by the defendants. However, that sale deed was not produced during the trial as well. In discussion of this issue number 3.
How does the suit proceed? You see, how does the trial court, executing court deal with order 21 of 99 application?
Lordship, that fails because of the observation, your lordship may come to pay.
Issues in reviewing the suit, because we not trial that document. Would it enable the court to say that no issue will be framed and we are passing an order and the order 8 to 10? Summarily, without any issues, then issues can it be executed like that? Supposing you fail,
Lordship.
document. Will it permit the court not to frame issues and decide the suit?
No, lordship. In this case, they have preferred the petition under section 47 or under order 21, your lordship. It was the duty of the party which alleges something to produce the document because
that duty, what is the corresponding duty of the court? Assuming she is wrong,
lordship.
she has not produced a document.
Lordship.
Let us transpose it into a suit.
Yeah.
What happens if a plaintiff files a suit and forgets to file any document?
the plaintiff may take the leave of the court and file it later on, Your Lordship. Here, that was not done. Even during the pendency of the suit where she was not a party, the defendants alleged the same documents to be,
That we don't know.
Lordship.
We get many abusive suits.
Lordship, the issue number
We
3,
can take a defense and then say that, no, I am not there.
Lordship, the issue number 3 precisely dealt with those documents, Your Lordship. That was, she was not a party to that.
Yes.
In this also, Your Lordship, she prefers a petition, Your Lordship, and the documents which the parties take support of are not produced before the court. Lordship may peruse section 141, Your Lordship, CPC.
Same procedure as a suit.
As a suit. The proceeding under 47 or under order 21 will be following the same procedure as a suit, Your Lordship.
Yes.
And for that matter, if we take order 8 rule 1A for the written statement or order 7 rule 14, Your Lordship.
That's not a clause. Under order 7 rule 11, reject the text.
Lordship.
For not filing a document can be plainly rejected.
Lordship, but it has to, the document has to be there, Your Lordship, to lead evidence on that part, Your
I
Lordship.
understand. But will affect that. If a document is not filed,
Lordship.
then you can take a plea that under order 7 to 14, plea or that police can be granted.
Sorry,
Produce the document. But can it mean that the not filing of a document can be rejected?
cannot be rejected, but subsequently there will be no evidence to that effect, Your Lordship.
Don't know. How is it perceived? What is the course of action of the
Because the executing court has to be prima facie satisfied that the objection of the third party is an objection on merits, Your Lordship. Merely stating that there are some certain documents.
Just put it as a suit.
Lordship. But
Can there be a shortcut to the procedure? That no, in this case, document is not there. Therefore, what we do is that we change the decree. Or we change it rejected. If that is permissible in a suit,
that is what.
we'll admit it. Not filing of a document in a suit will be so fatal. Lead to rejection of claim. Because so many authorities will be very happy.
Rejection of a plaintiff may not be there.
How the
But
court looks
since-
at that document when produced.
Since a suit,
That document.
a suit has already been filed by the third party, Your Lordship. That is in its own course, Your Lordship. They are reopening this as well, Your Lordship.
No. That's why we are telling you this.
Because their prayer in the petition, Your Lordship, was not for stay of the execution proceedings, Your Lordship, till the disposal of the suit. They prayed for, Lordship may peruse the prayer, Your Lordship, dismissal of the execution proceeding altogether in view of the ground taken by them.
That court will take the court. Can we take up the ordinance that no? What about one has to deal with the existing petition, the dismissal of the application on the order. Under under section 45 or 31 from 99. They're not the work to do that.
page, Lordship, 84 and relevant portion, page 86.
Hazarika.
One to 16. 16. No, Lordship. I am for the decree holders only, for the judgment is taken. Page 26.
The petitioners are third party to the proceedings of, I think, the TX case on the 10th of 2021. Has been
Judgment, page 15.
dated 21/12/2020.
21/12/2020.
Very learned concept from Sarnara Kamagaburi in PS number 43 of 2017. The petitioners having independent right at the expression of the written land had filed the order 98 it was number one. Select civil judge within bracket unit division of Sarnara Kamagaburi. Order dated 13/8/2024. On the ground that the petitioner has not produced copy of the registered sale deed to the title of the suit grant. So, from the petition number 1344 of the 2022. in terms of Article 3 of Order 21, the CPC. Any application made on an application under Order 19. Or the same conditions has to agree or otherwise exhibited by the decree. Next slide. So the preparation of decree as provided section 2 in the decree of the CPC. Rejection of plaint must be deemed to be a decree. The objections made under 51 but the entailed questions to be determined under section 101, rule 101, order 31. The questions are determined P1 within the meaning of rule 98 of order 21, which according to rule 103 is decree. And the rejection of the attention is also among the decree. Order and appeal by against the order dated 15/8/2022 and included in this application. For the on 6/6/2025. And spend the 1/6/2025. Time spent.
Article 14 of the limitations.
That is the limit of fee. In the Article 14 of the Regulation Act. for period as indicated. Very good.
Regarding that pending suit, lordship, that is title suit 80,
Out of visitors number.
বাবা খালি করে দিন।
Done by the. Daily proceedings of exception case number 10 of 2021. And today. Out of busy case number 4 of 2022. Also in this history, and we can explain it. Send you back.
Lordship, the registry will send back the TCR.
That is no MSD one for 22 is otherwise, so in that day you have been given divided to family.
Lordship,
Doesn't matter.
to file the appeal, lordship, miss appeal. The 22 June, 2 weeks may be granted.
22, 22, 26. I think it's a in the education property. And if you can take your cost.
Lordship. Lordship, the earlier suit which was filed by the petitioners, that is title suit 80 of that will proceed, lordship. There is
Not that thing. There's no.
Lordship. Yes, lordship, that was filed before execution petition.
Yes.
Lordship. I'm deeply obliged.
Item 8 or motion.
আমি appeal lordship. Yes, my lord. My lord, in this case, my lord, petitioner files CRDB against the husband in the present case. Ground, my lord. Already one divorce case filed by the respondent, and that case was, my lord, paying for transfer, and this case, my lord, is the proceeding, my lord.
No, what is the ground on which you're seeking transfer?
Yes, my lord, yes, my lord. Ground, my lord, para 7.
Tell us, what is the ground? If
Yes,
I read
ma'am.
everything, then.
Yes, my lord. She is residing at Udalguri, my lord.
Okay.
A distance from Udalguri to Nagamundar about 220 kilometers. And she is living under poor condition, my lord. And the respondent file, my lord, present case is before the granite addition session at Nagamundar. Earlier also filed one
a matrimonial suite, my lord. And that suite was challenged before this honorable by praying for transfer, my lord. And that proceeding was stayed by this honorable court, my lord. And petitioner filed a CIDB case, my lord, before the granted court, my lord.
Having custody of the child.
Yes, yes,
Who is having custody of the child?
petitioner, my lord.
Petitioner.
Yes,
And she is residing at Gauhati.
Udalguri.
Transfer of the proceedings and pay the treatment. The petitioner is residing at a current home at Dalguri, and the minor child is in her custody. And she's taking care of the child. Dalguri. Accordingly, this is the charges to what has been filed for the court. It was agreed. Case number 26. Indian Republic of
God bless.
Item 9.
May please, Your Lordship.
yes,
Lordship, I prefer this transfer petition for transfer of the
What
title
ground?
suit from Goalpara to Gauhati.
on what grounds?
Lordship, the husband has filed a suit there seeking annulment of the marriage on the ground that the petitioner has hearing impairment. That is the only ground. However, the fact of the matter is that in the petition, they have said that they have realized that within a day, they realized that she has hearing impairment. However, immediately after marriage, she was suffering from fever and all the related ailments. They did not treat her. As a result, she had to take recourse to her parents. She went to her home, and when she decided to come back, they said that they do not want her back. That is the basic facts of the case. Now, Lordship, since she is staying with her parents, her permanent residence is of Bhopal. Now she is staying here in Gauhati and pursuing her bachelor's. Her mother, in her family, only her mother is earning right now. She has two sisters, and she has a father who is now ailing, and she has a grandmother as well who has to be taken care of. She's fully dependent on her parents, and this distance, and if she has to go to Goalpara, that would be a distance of 220 kilometers, which Lordship knows it probably would take her 4 to 5 hours a day. The next, the medical documents of the father as well. It is a annexure number 4. And Lordship, in the meanwhile, if I may take your Lordship to page number 28.
Justice said that from the perusal of the report in the second paragraph, perusal of the report confirms that the summons notice was duly served upon and received by the defendant on 25/2/2026. Despite the service of summons and expiry of the statutory period for filing the written statement, none has appeared on behalf of the defendant. No application for an extension time or adjournment has been made. It has been declared as ex parte by the civil Sharistar. The PO was on leave, on child care leave. And moreover, the notice that was served, Lordship, if I may take your Lordship to that annexure, page number 17, page number 16, annexure 1, Lordship. Lordship peruses page number 16, annexure 1. Lordship may see that this is a notice that was given to us. It has no sign and seal of the court. It doesn't sound like this. And immediately after that, they have passed this ex parte order, and that too when the presiding officer is on childcare leave. Lordship, my only condition is that when a family condition is such that she is not able to, she will not be able to incur the financial burden as of now. There is a case that she has filed here in Gauhati for maintenance. Yes. Much obliged.
My lord, may I go through the LCR witness? All right.
Kohima bench item for orders. IA Civil 76/26.
Okay. Mm. Uh, If you have the order passed to the, if you have the disposal of WBC 57 of 2026, this interrogatory application stands closed.
Item 11 for motion of principalship.
Against reversal of judgment, my lord.
If you have reversal,
Trial court has passed judgment dismissing the
you are the tenant or the landlord?
tenant, my lord. Page number 131.
Mr. Sharma, two important issues are decided against you.
My lord.
First is about the rent.
Yes, my
And
lord.
second is that in the NJ cases, you did not prove the lawful tender of the rent by not producing the treasury challans.
First, my lord, rent, my lord. First decision about rent, my lord. The learned trial court has, did not accept my the written rent note, my lord. Written rent note, whereby written rent note. They have claimed that the tenancy started, from the starting of tenancy, rent was 3,200 per month. But there is one rent note, my lord, that suggests that rent was rupees 401 per month at the starting of tenancy. So, my lord, they have exaggerated the rent amount. So, my lord, this here, my lord, it's page number 162, my lord.
My lord, so far as I don't know what from my here, the page serial is made only up to 130. Thereafter, there is no page serial. After 113, page number 12 has come.
Mr. Sharma.
My friend was there, he could have told me, I would have met the.
No, where to tell you?
I was there. He
You
could have
find
told
him
me.
daily, day in, day out.
They are
Mr.
sitting
Sharma is
there.
not the person who can this. You both stay in the
Now-
same bar,
now he
same
is
court.
making- But here, my lord,
No, but he is right. You see, you got a copy. It is not the case that you are not in speaking terms with Mr. Sharma.
no, that is not.
Then,
Because
when did you get this copy?
this copy, my lord, it is most probably my, this thing. One of my colleagues,
It's okay, but when did you get it?
day before yesterday, most probably.
Day before yesterday. So you had 2 days time to tell him that his documents are not there. Give a copy, we'll take it up on
Documents are
Monday.
there, only numbering is not there. Page numbering is not there.
Give a copy, we'll take it up on Monday.
Let me complete the page number and all.
Give it to him, we'll give it to you. We'll give you a fresh
Only
copy.
page number. My student friend could have told me that we are sitting.
Yes,
here
that
since
is
2 hours.
right. It is not that you are not in talking
No,
terms.
there are already page numbering is there, but this has got no relevancy.
You see, these are, I don't expect Mr. Sharma to do it, all the compilation, stitching, making copies and giving it to you. Do you expect Mr. Sharma to do all these things? No, he'll either engage a clerk or he'll assist, one is assisting junior to assist him for that. You could have told him he'll get you a copy. These are complaints I don't entertain. Things which can be sorted out outside the court should be done outside.
It also pains me to inform.
No, why it should pain you? You have told him. It's a minimum courtesy you can show to the other side. You can just tell him that this is mistake, give me another copy. Had Mr. Sharma denied that copy, then we would have taken care of it. Give copies and all, in my court, I don't ask, I have never passed an order that give copies. We always tell that exchange copies, you give it. Have you found any of my orders where I say that copy is not, you give it to him?
No.
There's no order of my, I don't remember passing any such order, except in circumstances when both sides don't agree to something. Only in these rare cases, I say that copy would be served within the course of the day. Otherwise, I don't say that. Okay, list. On both sides are represented based on 8/6/20, paid for by the council for the respondent. Copy in the course of the day.
Yes, sir. Sorry, somebody
Discharge the caveat. You are a caveat.
with you, correctly.
Caveat discharge will be high. Okay, item 13.
Item 13.
At the stage when you file this application for agreement,
So Lord, it is regarding amendment, my lord.
I understand,
Amendment
but
is
what
not
is the
allowed.
stage, what is the stage when you file this application?
Impute order at page 43. The relevant portion at page 47.
No, no, I am not on that. We are asking you at what stage did you file this petition for amendment?
My lord, just a written statement has been filed. Issue is not framed, nothing.
Issue not framed,
Not framed.
but in this objection,
My lord,
sorry, not in the objection, it is somewhere use the cases ready for hearing. Yes, page 32.
my lord.
You have made a statement in order 6/17 application that the above noted case is fixed for hearing. Hearing means the evidence must have started, otherwise the case is not fixed for hearing.
My lord, it is wrongly written. Only WS has been filed, my lord. Not hearing.
Now you see, in their objection at page 39, they take a plea that earlier you had filed order 6/17 on the same facts,
My lord.
which was disposed of on withdrawal,
My lord.
but you were not given liberty.
But that point, my lord, is dealt with by the court below, my lord. That it was only withdrawn, so that judicature will not come.
Third, Mr. M.A. Sheikh, learned counsel for the petitioner. You are paying for the government.
I am for 5, 6, and 7 also. State respondents.
Government advocate affairs for respondent numbers 5 to 7. Next one. Agreed by the order dated 4/4/2026, passed by the learned civil judge within bracket senior division bracket code Dhubri. In this case, thereby rejecting the prayer for amendment Under order 6/17, if you see it registered as Miss J case number 37 of 2026 in TS 71 of 2024, while the present application has been filed under Article 227 of the Constitution of India. It stated that while filing the suit, there was an inadvertent mistake in the naming of the revenue circle and the revenue village, which is sought to be altered in by way of the amendment. As per issue notice, returnable on so. Petitioner shall take steps within 2 days for service of notice on the petitioners. Shall take steps within 2 days for service of notice on the respondent. Respondents by speed post with AG. Next, the learned counsel for the petitioner shall correct the postal receipt number and submit postal tract report prior to the next date of listing. Next, till the next date of listing, the further proceedings of TS number 71 of 2024, pending before the learned civil judge, senior division, within bracket, senior division, bracket was Dhubri, shall remain stayed. Next, the petitioner shall produce a certified copy of the order before the said learned court to bring the order its notice. All right.
July.
Item number 14.
Item 14.
My lord, it is out of same case, my lord, but in this injunction petition amendment.
So same
Schedule, injunction.
Okay, the order will be same. Order is also same date.
Same only order
This case, it will be in this year, in this case, 38 of 2026.
38/26, my lord, 4/4/26.
And um, the
Page 44, my lord.
the order is passed, the order dated 4/4/2026 is passed in BJ case number 38 of 2026 in connection with injunction which is registered as BJ case number 38 of 2026 in TS 71 of 2024. That is the only correction. Okay. Sir, just before that you say, extra copy, requisite extra copies of the application be provided to the government advocate within 2 days. Okay, in both the cases, no? Okay.
Give your-
Item 15.
May I please, my lord? My lord, in this present case, my lord, the present petitioner has been plaintiff filed a suit, my lord, before the learned court below, my lord, to recover an amount of rupees 5,80,000, my lord. So after payment of issue, the my lord, the present petitioner filed evidence on affidavit, my lord. During that period of time, my lord, due to some miscommunication between his earlier counsel, my lord, he changed his counsel and engaged with the present set of counsel. After, when the present set of counsel, my lord, go through the entire record, my lord, he found that there is some formal defect, my lord, in the suit, my lord. Then, my lord, he advised his client to the present petitioner to file a petition to do this suit in liberty to file a case, my lord. Accordingly, lordship, it is on page 27, my lord. This petition was filed, my lord, under order 23, rule 1, sub rule 3, my lord. This
Where is the petition?
page 27, my lord.
Is
Yes.
only an affidavit.
My lord, page.
Oh, acha. Okay, oh, yes. But in this petition at page 27,
My lord.
you have not stated what is the mistake. You have not even stated that the suit will fail because of the formal defect.
My lord, but
What is the defect?
my lord, actually, my lord, defect is that, my lord, there is some calculation mistake, my lord, and
No, you have to point it out because if
Yeah,
we
my-
don't
my-
understand, we can't permit that.
I admit, my lord, my problem is that, my lord, if I pointed out this everything in this petition, my lord, then, my lord, my problem is it will come to the record, my lord. If, my lord, my lord, if
But there
this
is no
petition is
ground.
not allowed, my lord, then, my lord, I will be suffer, my lord, during the
But
course,
there
my
is
lord.
not ground because the court must be satisfied that the suit will
But
fail. You see,
even-
you could have amended amended your plaint.
My lord, but my lord, whatever, my lord, there is some calculation even, my lord. Even, my lord, on the based upon this calculation, my lord, even, my lord, my suit value will be changed, my lord. So, my lord, during the argument, it was all described before the court, my lord.
No, no, no. You see, you must argue with the court on the basis of whatever is there in material. You can't be permitted to travel outside and sit tell court what is
But, my
not
lord,
your pleaded case.
in para 5, my lord, it is categorically stated that, my lord, it cannot be amended by way of amendment, my lord. Cannot be corrected by way of amendment.
No, no, there is nothing on earth which cannot be amended.
But, my lord, there is some, there is, my lord.
You see, when you can by an affidavit change your name, what is there which you can't amend by way of an amendment?
But it will be create another problem. My lord. So, my lord, he decided to.
No, no, the court must be very satisfied because you see, you are asking for a liberty to come afresh.
Yes, my lord.
Where is your plaint?
What will I come to page 13, my lord? My lord, my main problem is with para number 3, my lord. Where, my lord, it was stated that I received the amount of rupees 4,15,000, my lord. As per, my lord, plaintiff, my lord, he never received an amount of rupees 4,15,000, my lord. Though he received some amount, my lord, by way of cash and bank transfer also, my lord. That is my problem, my lord. Even, my lord, if that is being calculated properly, my lord, my suit will also be changed.
The court rightly not permitted you. Even we will not entertain this application. You see, you have filed a money suit.
My lord.
In the money suit, you say that in 2018, he agreed to borrow money.
My lord.
Correct?
My lord.
Now, the date on which he borrowed is not there.
My lord. My lord. Yes,
Correct.
mistake, my lord.
So therefore, we will understand that in 2018, he borrowed.
My lord.
And you have filed this suit in 2022. It will be barred by limitation. Your cause of action becomes barred by limitation.
My lord.
Then how will we permit you to withdraw it and change, alter your position?
But my lord, there is some student incident also, he paid some amount after the
You see, that is the payment on account. Unless there is an acknowledgement within the meaning of section 18,
My lord.
the statement of account will start from the day when when the transaction took place.
My lord.
Can you extend the limitation?
No,
There is no acknowledgement of debt
my lord.
on a particular day.
My lord.
Therefore, you don't escape, you can't escape section 18
My lord.
of the Limitation Act, and therefore it is not extendable. And therefore, your cause of action itself is barred by limitation. You see, when you get a liberty to come again, that liberty must be that you will have to file the suit within the period of limitation. By permitting you to withdraw, doesn't extend the limitation. And even if we accept everything, please come to your print again. Now, here you say that on paragraph 2, you say that on 12/2/19, the defendant executed an instrument in your favor, putting his signature on a stamp paper of ₹100 and assured to pay 1065 only within 30/10/4/2020. So this becomes a hand note and or a pro note, whatever you say. And here, 12/2/2019. Now come to page 13. Your suit was filed on 28/9/2022, again after 3 years. You see the small endorsement there. Yes, my lord. 28/9/22. Therefore, your suit was filed on 28/9/2022. Your authorization is barred by limitation. Do you have that hand note with annexed here? No, my lord. Just not annexed. Do you have a copy for yourself? No. Oh, that agreement, I think. That agreement I have not. May I, my lord? My lord, as per the agreement, my lord, there is a condition, my lord, in paragraph 2, my lord. That's why there is 12/2/19. He had to pay of rupees 10 lakhs only within 34/2020, my lord. My lord, it is may not be barred by the limitation. My lord. Just a minute. My lord. Just a minute. Sorry, in the absence of any explanation in your application, you don't find anything wrong in the order of the learned civilian. Your application says nothing about that formal defects. No, Professor, we are not entertaining. The petition does not say what is wrong, what did not be calculated. Mr. K.M. Hassan and counsel for the petitioner. Next one. By filing this application under Article 227 of the Constitution of India, the petitioner, who is the plaintiff in money suit number 9 of 2022, has assailed the order dated 26/3/2026, passed in Ms. case number 16/2026, which was an application filed under order 6/17 CPC for amendment for no, not orders. It will be ordered 23 within bracket 3 of the CBC for withdrawal of the suit with liberty to file afresh. Next, right is the counsel for the petitioner has submitted that the suit was filed to another set of counsel, and in the course of the said suit, the petitioner had filed the evidence on affidavit drafted by the earlier engaged counsel. For some reasons, the petitioner took no objection certificate from the earlier set of counsel and engaged a new set of counsel to take further steps. It is submitted that on scrutiny of the plaint, as well as on scrutiny of the evidence on affidavit of the PWs, a new set of counsel found some discrepancies in the explanation of dates and events, as well as facts. Accordingly, the new set of counsel was of the view that the entire facts should be disclosed before the court. First of it is submitted that the new set of counsel also found that there was some error in calculations and other technical defects in the plaint, which could not be amended by way of an amendment under Order 6/17 CPC. Therefore, the petitioner was advised to withdraw the suit and to oppose the court again, as it would be difficult to correct all the inadvertent mistakes which are technical in nature and it portrays an incorrect fact before the court. Pushpa. The respondent contested the application by filing objection. Mr. The learned civil judge, senior division, Tapsal Mara Mankacha. And the order dated 26/3/2026 rejected the said application. Next up, the learned counsel for the petitioners further submitted that as this was a money suit and any premature disclosure of the nature of defects which has occurred in the claim would cause prejudice to the petitioner. So accordingly, submitted that the impugn order was perverse without without considering the facts and circumstances mentioned in the said petition. And accordingly, the impugn order was bad in law. So he submitted that. Next, it was submitted that in the petition for withdrawal, it was categorically mentioned that there were some unexplained list of events which is required to be more fully explained, and that the error in calculation would be fatal to the plaintiff in the adjudication of the suit. It is further submitted that it is the fault of the learned counsel for the petition should not be made to suffer. Next one. Having heard the learned counsel for the petitioner from where is the materials available on record? So in the plaintiff, the petitioner had disclosed about the outstanding and dues of rupees 5,80,000 receivable from the respondent. So how reading of the plaint. So, however, on a perusal of the amendment application, the application under order 23 rule 13 CPC, it is not seen as to the nature of calculation mistake. And the so-called technical defects. Thus, the explanation of the reasons why the petitioner desired to withdraw the suit is not properly explained. First of, in that regard, the finding of the learned court below. The learned cannot be said to be either bad in law or perverse. Full stop is on a perusal of the provisions of Order 23, Rule 1 within bracket 3, CPC. Comma, the court is required to be satisfied that the suit must fail by reason of some formal defect. And alternatively, the in addition to as well as an alternative to the above, the court is required to record its satisfaction that there are sufficient grounds for allowing the respondent or the plaintiff to withdraw the suit only on existence of sufficient grounds for allowing the plaintiff to institute a fresh suit. Next, finally, said application under Order 23, Rule 1 within bracket 3 CPC, which was registered as Ministry case number 16/26. It is vaguely stated that there is a calculation error of the dues and there were technical defects in the plaint. So the nature of error in calculation or the nature of technical defects has not been stated or explained. Next, accordingly, we see that the learned trial court took cognizance of the fact that the power under Order 23, Rule 1 within bracket 3 is required to be exercised with caution and circumspection. And as the petitioner has not stated anything about the nature of formal defects in the suit for which the suit was likely to fail. And moreover, the petitioner has not spelled out the nature of formal defects which contain the plaint. Accordingly, the interim order dated 26/2016 asked by the learned civil judge within bracket senior division bracket post South Salmana Manchester in connection with Ministry case number 16/2026 in MS 9/2022 is not found to be suffered by any formal any defect or perversity. Accordingly, this application from the same is dismissed. Next, the registry shall transmit a download copy of this order to the Court of Learned Civil Judge with invited criminal reason concludes such a market. This will be made a part of the records of MS 9 of 2022. Authorized. Item 16. Yes, there is the order of injunction.
No, that order is at page, the appellate court had granted the injunction,
Yes.
trial court refused.
Yes, yes.
Appellate court's order is at page 22.
20.
The huge order.
That is why you,
And the fact, by
just, no, you said it was a huge order. That is why you,
well, if your lordship permits, I can give the facts in a nutshell.
yes,
Well, plaintiff filed the suit for declaration of title and recovery of possession. And they have also challenged the sale deeds in our favor. Their case is that from the original owner, their predecessor took lease way back in 1954. And defendant number 3 was inducted as a permissive occupier by the plaintiff. And only in the year 2019,
you are the defendant in the suit.
yes, ma'am. And only in the year 2019, they have discovered, because they themselves have stated that we have shifted to some other place. We do not stay here. And we inducted defendant number 3 as a permissive occupier to stay in one room. And 2019, they say suddenly they have discovered that there are sale deeds in favor of the defendants. 2 sets of defendants are there. In fact, 3 sets, my lord. Third set is the, my lord, the legal heirs of the original owner. Now they have challenged the sale deed, saying that the vendors of the defendants, simply one sentence, do not have the saleable interest and nothing else. Now, apart from the written statement and written objection filed by the defendant number 2 sets of defendants who have purchased, my lord, the third set of defendants who are the legal heirs of the original owner, they have come up with a story that yes, lease was granted to your predecessor, to the plaintiff's predecessor, but in the year 1979, you have left and you have surrendered possession. And thereafter, there was a mutual partition of the land, and we are the legal heirs to one of the sons of the original owner. And we have sold the land to 2 sets of defendants by this registered sale deeds, and therefore they have filed a counterclaim also. Now, Learned Trial Court, considering all these aspects, refused the injunction, saying that they have purchased it. And so far as First Appellate Court is concerned, my lord, First Appellate Court has recorded the entire story, but while recording a finding without considering as to what will happen to this prime facie case, etc., simply says that now we will not.
No, because you don't change the suit property, you don't induct a third party. This is a good order.
Well, it's good order otherwise, but here fact means that when the defendants have come up with a plaintiff is very silent about how we have the persons who our vendors do not have any saleable interest. Original owner had 22 bighas of land. Unless they say specifically that out of the 22 bighas, your vendors did not have saleable interest in respect of these 9 cutters of land only, then matter would have been different. They are silent. They are simply saying one sentence and throw from their plaintiff. One sentence that they do not have a saleable interest.
No, but the ultimate fact is
My lord.
whether you want to sell or dispose of property or
My
invest in
lord,
third
but
party.
we are very clear. We do not want to sell, but we want to construct a house. We have purchased.
So that has to wait. You can't change the nature and character of the suit land.
If we construct, we will be constructing it our own peril. Now we have purchased the land. The vendor themselves say that they have right. You do not say that these vendors, except for one sentence, the vendors do not have any right. Vendors, my lord, they have given.
Mr. Mazumdar, nowadays, the amount of cost which is taken to build the house,
My lord.
more than that it will take to demolish the house. That is one. Second is for the construction of house, you will get materials everywhere. But after demolition, to throw the garbage here and there.
Correct. Yes, one truck of debris, one has to look for place where to throw.
Where to throw.
Very difficult. Very difficult.
And the municipal corporation doesn't take it, the committees do not take that.
My lord.
So that's the problem.
That is there.
And we have faced that.
I also feel it. Yes. Yes. Waste. Doesn't fall in the category of waste. And I don't know whether Lordship is aware, if it is burned, objections come from the neighbors. Ah. Compost. Yes. Firewood. Firewood. Yeah. Nah. Officially, it's very difficult. Otherwise. Well, my submission is very limited. My submissions, my lord, so far as if the vendors would not have come forward to file a written statement and take a stand, they have filed a counterclaim also challenging their right. Now, in view of this, I think, my lord, in my humble submission, the plaintiffs do not have the prima facie case. They cannot prevent us from making the construction. Defendants who are the owners, they have taken a specific stand that you have surrendered your possession in 1979. After that, you are not here. And plaintiff also clearly say that we have shifted. And they do not give the date when they shift. Defendant number 3 has been residing. There is one external house is there. She is residing there, defendant number 3. According to them, she was inducted by them as a permissive occupier. She has filed in our written statement as well as objection. She has said, no, you have not given. The other brother's son has given me the permissive occupation. I am still staying there. And she is still staying there. Who has got a better case, my lord? Plaintiff has admittedly left the place, shifted according to them, and without giving the date. Deliberately, they have not given the date as to when they have shifted. Now, vendors have come forward saying that, no, you have shifted long back, 79. And after that, we have given settlement, our permissive occupation to defendant number 3. The statement is they do not pay lease, rent. They do not do anything. They've given up the surrendered possession. They have left that place. Now, when the original owners sell it to us, now they come forward say that in 2019 I have come to know about your sale of 2018. trial court has mentioned all the facts in detail and rejected their petition. Yes. No. Now, so far as possession is concerned, it's the admitted fact that I am possessing defendant number 3 and all others. That is why there is a prayer for recovery of possession. Well, plain Lord will kindly see. Starts from page 55, madam. And page 62 is the prayer, madam. Page 62. A decree jointly and severally against the principal defendants for declaration of right of the interest of the plaintiffs over the property mentioned in Schedule 1 below, or getting khas possession of the suit property mentioned with the Schedule 1 below by evicting the defendants and or any person, cancellation of documents mentioned in Schedule 2, all those same deeds. And page 82, Lord, you will find in a 144 proceeding, our position was confirmed. Page 82, madam. Page 82, para 23. That suppressing all those facts, the plaintiff number 3 filed a proceeding under section 144 CFPC against the answering defendants before the district magistrate Kachar Silchar by case number censor with all false and baseless statements and allegations against the answering defendants. In the complaint petition under section 144 CFPC, the plaintiff claim that they are in possession of the proceeding land and the answering defendants are trying to take forceful possession of the suit land. Such stand of the plaintiff is absolutely contradictory with the contention as made in the present plaint and injunction petition. Said under section 144 CRPC proceeding converted under section 145 CRPC. In the said proceeding, an order was passed for a local inspection and the learned ADM conducted local inspection, and such inspection report also clearly shows that the unsigned defendants are residing in the said premises as described in the schedule below since long. However, the plaintiff petitioner did not proceed further with the said case and ultimately said proceeding under section 140 CPC was filed for non-prosecution on 30th of August 2019. It is pertinent to mention here that during pendency of the said proceeding under 145 CRPC, the plaintiff petitioner number 3 also filed LG case number 7 in the Court of Edition Session Judge Kachar against the unsigned defendants and other alleging that the suit land is under their possession and unsigned defendants are trying to grab the said land. And the said LG case number 7 was also dismissed by the court by order dated 22/7/2019. And in the plain manner, they have clearly said we are in possession. But they have only taken a plea that they have inducted us, whereas the vendors have said, no, you have never, we have inducted you. No, yes, by the appellate court, trial court rejected. And it will be 227 only. In the office, my learned thing says that in the office they have made it IU in registry. It was initially CRP only. No, this is a revision, man. 27. Right? 227. Trial court granted the injunction, refused the injunction. Then they filed an appeal. Yes. If we go by the proviso to 115, It says if the order was granted in my favor, it would have disposed of the suit itself. So it's a, and that reflects the judgment in a lot of way, I think that. In an inaction matter, it will be revision possibility. But if the order was granted in my favor, then the suit would not have still been disposed of. Suit will still remain. And I think that judgment of 2003 is Malik. Otherwise, the judgment possibility of Supreme Court is very clear. In that case, that was the issue that in a revision, after appeal, whether it will be a, I think the judgment today, and I have not got, I can. Malik.
In Miss Appeal number 1 of 2022. Just a moment. First Supreme Court, that is Civil Judge Senior Division number 1, Kashar Switcher, thereby granting identity temporary, granting identity interim injunction restraining the petitioners from raising any construction or changing nature and character of the suit property. First off, the learned senior counsel for the petitioners has submitted that the trial court had the trial court by an order dated 25/11/2021 passed in BG case number 167 of 2020 in TS 147 of 2020 had refused to grant injunction. Next paragraph. He submits, he also submits that as the the petitioners have not filed his application under 115 CPC as if the order is passed in favor of the petitioners, it could not have disposed of the suit. And therefore, the application is made under Article 227 of the Constitution of India. Next paragraph. Issue notice, including notice of the prayer for interim relief, returnable on so and so, due date after 4 weeks. The petitioner shall take steps within 2 days for service of notice on the respondents. List on so and so for consideration of the prayer for interim relief. Item 18.
Item 18.
If I appear for the petitioner,
Yes.
we are seeking a setting aside of the interim judgment dated 10th of April 2026. We're seeking setting aside of the interim judgment dated 10th April 2026.
Page.
Your Lordship. Uh, the impugned judgment is at page 15, Your Lordship. The trial court has allowed the amendment application filed by the plaintiff in this matter.
Yes. How you agree with that? Or
Yes,
why
sir.
is the order wrong?
Yes, Your Lordship, that in this particular matter, the trial court has failed to take note of the fact that the plaintiff has essentially tried to restructure the suit to this amendment application, Your Lordship. This particular suit, manuscript number 119 of 2019, has been pending for a very long time. It was the plaintiff's case that while preparing for the evidence stage and while going through the pleadings, did they realize that certain material documents and including the total amounts that they were seeking were incorrect. And it was only after going through the defendant's written statement did the plaintiff's counsel realize that these materials, facts, and documents are missing from the petition, from the claim, whereby they sought to amend the petition.
But it is only the few amounts have been they're sought to be altered. 23 is lakh 60,000 to 2835. How that is?
Not just amounts, Your Lordship, they have including one is of course the amount. Initially, they had sought a relief for a sum of rupees 23 lakh 60,000. Then they improved the amount and now they're seeking a relief against the sum of 28 lakh 35,000. They are justifying this change or miscalculation as a typographical error. Furthermore, they are saying that they had not filed any authorization letter in favor of the director to represent the company. So that this apparent board resolution was issued in 2019. However, they forgot to annex it. And all other documents that they sought to file, including the ledger statements, the bank accounts, the partnership deed of their sister concerned firm, all of these are documents that were very much in possession of the plaintiff company, that is. They are saying that the plaintiff is a layman and therefore they did not know the law and hence essentially forgot to annex the document. There was absolutely no due diligence done by the plaintiff's counsel, which is why they did not annex these documents at the initial stage, and now they're seeking to instance the case after going through the written statement of the defendant and realizing that there is actually no cause of action for them to pursue this case. And because the limitation has lapsed, they don't really have any other remedy to seek additional claims, and therefore they have sought to improve their petition by filing this application.
We don't think so, because you see in page 43, the application, they say that document number 6 has been submitted in respect of 2035. So it has to be a mistake.
I'm sorry, Your Lordship.
Page 43, they say that this is the reason, and again,
Page 43 of the list.
so therefore it is, they've given the explanation of how they've arrived at the calculation, and they say it's a mistake.
Your Lordship, that mistake happened because the council, whoever were engaged initially, probably did not undertake the task correctly, or there was,
Whatever, but that's a mistake. Why mistakes cannot be allowed to be calculated, to be incorporated by way of an amendment.
yes.
Therefore, what is wrong with that? And you've been awarded cost for that, the delay and all, they've been taken care of by giving you a cost. The suit is filed in 2019,
Yes.
and whatever transaction is being shown is within that period.
Yes, Your Lordship, the documents that they are willing to bring on record through this amendment application was always with them. It's just that when the written statement of the defendant highlighted every loophole and essentially said that they don't have, the plaintiff company doesn't have any cause of action to file the suit against the defendant number one, that is when, after perusing the written statement, the new set of counsels that the plaintiff company has engaged realized that they don't really have a case because the necessary documents, which is already with them, were never filed. They did not undertake due diligence.
No, that's, you see, that's not that's not for us to determine at this stage. The fact is that the change of the amount from A to B is not setting up a new cause of action. You see, due diligence does not mean that every time people will be calculating the dues and all, they make a mistake and then they approach the court. And if it is not set up a new cause of action, why this amendment should not be allowed?
Your Lordship, because the proviso under section 17 very clearly says that provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial.
Yes,
Your
that
Lordship,
is why they have justified it by showing that there is a change in counsel and therefore they found out.
Your Lordship, but they also say in para 5 of the application at page 47, there the justification is that on perusal of the order sheet, it shows that the plaintiff has engaged the present set of learned counsel who appeared on 30th March 21 by filing Vakalatnama.
Just a moment. How does this name comes here? This page 45, there's a name of a shop.
Page 40.
45. This is this is one of the parties here.
I will check this.
Page 45. There's a reference to a shop in the first line.
Yes, Mrs. Singh Cycle Stores is a partnership firm. Yes.
This is one of the parties here.
It is not a party. The company is Fortuna Copia. That is before this.
No, not before me.
I'm sorry?
Not before this bench. Okay, just say that this is started before any other bench without me. Here, Suramaji. I would not be liking to take up the matter. Committee. Item 43.
Your Lordship, this matter is actually coming up on 9th of July before the trial. So
We'll have to make a mention before any of the because I can't take up the matter.
please.
Please, Your Lordship. Here we are challenging the order dated 10/11/2025, whereby my prayer for condoning the delay in accepting written statement has been rejected. The impugn order, Your Lordship will find page 62. And with the order, Your Lordship. 10/11/25.
But the order is correct. What is wrong in the order?
Your Lordship, although there is a delay of 285 days, I have explained the circumstances under which I could not approach this.
So the trial court, you see, has
Trial
passed the order on the
Yes.
ground that
We could not.
there is already an order for to proceed ex parte that was not set aside.
Yes, that was not, we did not file necessary
Then-
application. But thereafter, we came up with this section 5 application to condone the.
No,
to condone the-
written statement can't be controlled under section 5. It's not a, the section 5 would not have no application there.
Your Lordship, one similar order was passed by the civil judge, junior division, number 3, which I've annexed at page 68. In this matter, under similar circumstance, page 68, 19/11/25, Your Lordship will find.
68.
68. There also the facts are similar. In fact, I am also the defendant in that title suit.
No, in the matter of written statement, section 5 is not applicable.
That,
well
that
settled.
is probably correct, but Your Lordship,
The judgment in that is the Salem Advocates Bar Association.
yes, yes.
Yeah.
Section 5, but there was a delay. Because the statutory period that was already over.
No, but the court says that you have not asked for the setting aside of
Setting
order
aside
6,
of the,
order 9 rule 7,
yes,
that you
That-
could have still filed. You have not done it. You filed section 5 instead. Section 5 is not tenable.
Your Lordship, may I read this similar order, which was
No,
allowed?
you see, the order of a municipal would not be a binding precedent on this court
Yes, and then that,
unless you show us either the order of a 40th bench or larger bench of any or sorry, the of any other court or the Supreme Court.
Your Lordship, there is a decision in regard to the fact that CPC is a rule of procedure. Strict rules should not be followed. So,
No, but in an application under section 5, we can't say that. Procedural law is that there is an order to proceed ex parte. It is a requirement of law to have it set aside or recalled.
That was probably the
The
mistake.
trial court gave you the load. You did
Yes.
not venture there. You filed an application under section 5.
In the meantime, the PW witnesses that has, the trial has started.
But you can't do anything. You have to show us that the order suffers from any illegality. You better withdraw this and go to the trial court again with order 9 rule 7.
Your
Do you
Lordship, can
liberty?
I urge one point that the litigant, he was probably not having the technical knowledge. So for
No, but
that,
in every case, you see, there is a lawyer behind. So how can we say that the application under order 9 rule 7 is a defect which could not have been cured by a lawyer? Even here, we can't do anything. We can't interfere with the order when there is already an order to proceed ex parte. We can't assume jurisdiction. The order to proceed ex parte is not under challenge.
yes, that is,
Then how can you permit your evidence to be brought in? Better withdraw this and we'll permit you to go to the trial court with that.
that observation.
Mr. S. Datta, learned counsel for the petitioner submits that the petitioners are, you are also appearing, and Mrs. D.T. Burma, additional senior government advocate appearing for respondent numbers 8 and 9. Next one now. The learned counsel for the petitioners has submitted that the petitioners are ladies and senior citizens, and they had engaged a learned counsel to prepare and file their written statement, which was not filed within time. And therefore, the court, the Court of Learned Civil Judge within bracket Junior Division, bracket was number 3, had passed an order proceed ex parte against the petitioners. Full stop. This fact came to light when the petitioners engaged another set of counsel.
Yes.
Who had advised the petitioners to file an application under Section 5 of the Limitation Act for continuing delay of 285 days beyond the period of limitation in filing the written statement. Most of how the petitioners were not advised to file an application to set aside the order to proceed ex parte against them. And it is on that precise ground that the petition filed under Section 5 of the Limitation Act, which was rejected. Stop. Next, the learned counsel for the petitioner has submitted that the correct reports of law would have ought to have been to file for the petitioners to file an application on the orders on order 9 rule 7. So this issue for setting aside of the ex parte order is submitted that it is too well settled that the period of limitation to file written statement under proviso to rule 1 of order 8 CPC is not mandatory but directory. Accordingly, the learned counsel for the petitioners brave leave to withdraw this application and to move the Court of Learned Civil Judge within bracket Junior Division number 3, Sri Bhumi, with an appropriate application for setting aside of the order to proceed ex parte against the petitioners. In the earlier times, you did not file a written statement.
No,
Uh,
we've taken time, we sought time to file our defense as
Okay.
well as the counterclaim.
Okay. Now I'm asking you because there's no incorrect facts in the order.
Yes.
It's correct.
Yes,
So prayer is allowed, considered allowed. This applications stand dismissed on withdrawal with liberty to the petitioners as prayed for. Next, it is. Right.
Your Lordship may observe another thing that the WS as well as my counterclaim that is ready.
Hmm?
That is ready for filing. We have already annexed it along with this petition.
Okay, where is the written statement? Written statement was not filed.
A written statement was not filed, and we are also the counterclaiming. So both
No,
are.
no, counterclaim will not come on this written statement there.
Yes, yes.
So when you file your application under section 5, you did not file your written statement.
Yes, we filed along with it.
Where is that statement?
Mm.
Because here I have read somewhere that you have said that you are prepared.
Yes, I've
Prepared and filing are two different things. Where did you say that? I don't remember. I won't be able to find out again. You said somewhere that the written statement was prepared. That you have filed it is something we have missed somehow. Where have you said that you have filed it?
no, we haven't filed. That is prepared.
No, no. That we to wait for the court to record.
Because the written statement which we have annexed here.
No, annexed is something which is contrary to the document on record. The trial court will not have that. So this court cannot take into cognizance any document which is not before the trial court and base the orders on that.
Just a second, I'll check the record, Your Lordship, the order.
No, somewhere you have written, you have prepared. Where I wouldn't be able to locate. I just cursorily read it. I don't read it so thoroughly that I would remember it right now. But somewhere you have said, you search your petition, somewhere you have said that you have prepared a written statement and counterclaim. Filing is not mentioned. Yes, paragraph 3. The petitioner, the defendant prepared the written statement as well as counterclaim. You only prepared it.
So, Your Lordship, that means that that is ready for filing.
No, many things you prepare it, but maybe it is by hanging on the wall. Is it not?
So, Your Lordship, this
It
can
would
be
be a wonderful thing to hang in the wall, that this is the written statement my lawyer has prepared. Unless you file it, we can't take cognizance of that. I read here and there and come to conclusions. That is my problem.
Obliged.
For orders.
We get about 3.5 bags by the time we go home. So to remember where I have read what is very difficult.
Yes.
Yes.
For orders, item 25.
Maximum fixed for hearing. The service is complete. Maximum fixed for hearing.
Pardon me?
I mean, the maximum fixed for hearing.
Just a moment.
Okay. Show them this.
This will not proceed. Substitution was made. Substitution was made. Okay. The same none appears on call for the appellants. However, the respondents are represented. Next para. Still, an affidavit filed by the learned counsel for the appellants on 29/4/2019, stating that the appellant number 1 was informed by registered post regarding withdrawal of the wakalatnama. And accordingly, it has been stated that the counsel on record may be exonerated from appearing in the case. So the court takes notice of the fact that in connection with this appeal, an interlocutory application being IA Civil 1703 of 2018 was filed for restoration of RSA 85 of 2010, which was dismissed for default on 9/4/2018. And as per the Wakalatnama on record from the affiliates are now represented by Mr. R. Chakravarti and Mr. M. Saliha, whose Wakalatnama is available in IA Civil 1703 of 2018. It's noted that the application for substitution and sitting at judgment were also filed by them were also allowed. Next, accordingly, the registry shall reflect the name of Mr. R. Chakravarti and Mr. M. Salia as counsel for the appellant in the court list by listing the matter next. So this order may be brought to the notice of the AOJ, second appeal section, for doing the needful. Next para. Case is ready as regards service and the ACRs are received, matter is ready for hearing. Next para. As the suit is of the year 2010, this is the matter for hearing in the week commencing 27/7/2020. 706.
Or orders, item 26. May I please, Your Lordship, as per last order dated, my lord, service of notice of respondent number 9, my lord. The other side has to give us the address of respondent number 9. In that they are not giving any address. Order dated 1/2/2023.
Sorry, my lord, I was not there. Only because of 1/12/25 order, my lord. They have to inform us about the address of respondent number 9.
But how can he inform if he's not
Well,
aware?
because they are the relatives, same persons. There was a judicial order of 1/12/25. my lord.
But you'll have to find out, otherwise this,
Only because of the delay condonation application on the order 9, rule 7, my lord, that application was rejected. Our counsel was, my lord, he had an accident and he fall from the terrace. That is right. They are not appearing also, my lord.
you take substituted service,
My lord, your lordship.
other 2013, but I cannot.
My lord, your lordship gives me that permission.
Okay. Mr. P.K. Roy Choudhury, Commissioner Council, assisted by Mr.
Yes, sir.
S.
Ahmed.
Ahmed, Learned Counsel for the appellant, the petitioners have submitted that this court by order dated 1/12/2025 had ordered that whenever the counsel for the other respondent numbers 1, 3, 26, 8, 10, and 12 discloses the address of respondent number 9, all steps is required to be taken. Next para. As this revision is pending since the year 2013, and as it appears that the respondent number 8 was one of the plaintiffs and had disclosed the address given in the cause title. And subsequently in this proceeding, her address, the notice issued on the respondent number 9, sorry, it will be 9, has returned answered with the postal remark left. Comma. The court is of the considered opinion that as the respondent number 9 has left without disclosing any address, and that she is the plaintiff in TS2 of 2009, it would be appropriate to direct the petitioners to take steps for service of notice on respondent number 9 in a substituted manner by publishing the same in one vernacular newspaper which has high circulation in Hojai in the Nagaon district. Next part. And the notice the date of appearance should be provided as give a date after 6 weeks. The data also, the process shall be routed to the registry of the report, and the same should be published in the newspapers at least 15 days prior to the next date of listing. And an affidavit of service along with the copy of the newspaper as well as one photocopy of the relevant page shall be filed at least 2 days prior to the next date of listing. Next for list on. No, we have time to take the process 15 days before the next date. You have to wait have publication date and then.
But there was an interim order.
So there's no interim order. There's no notice also issued here.
In the main case, my lord.
Your interim order was discontinued after order dated 10/3/2014. After 2014, there is no extension of that interim order.
But it was, I think, that was still not for a particular period. It was continuing.
No, you see, something interesting happened. This court by order dated 10/9/2013 gave you a stay of that proceeding shall remain stayed. But then somebody made a prayer around 22/11/2013, the interim order passed to continue. Then again, there was a prayer and the extension order says of 10/3/2014, interim order shall continue till the next date.
So there was in between that. So in between that too.
The stay which was
for a longer period was cut.
For unlimited period was made
Short.
made limited by somebody who appeared on 10/3/2014.
But that court has not proceeded. That is all there.
It's okay. You file an application, no, to file an application for the extension of stay.
All right, sir.
Item 27 for order.
May I please, Lordship, I'm appearing on behalf of Learned Senate Counsel GP Bhumik, Lordship. PCR, Lordship, came and service is also completed. So kindly fix the matter for hearing, Lordship, the next.
Okay, your name?
All call.
Our court.
Yes.
Our court and counsel appears on behalf of the learned counsel for the appellant on record. You have the respondent. All the respondents? Sole respondent. Okay, sole respondent. Mr. S. Islam, learned counsel for the respondent is present. Next, as the matter is ready as regards service and TCR is received. This is the matter for hearing. 3rd August 2026.
of the item.
Item 28.
There is no representation from the petitioner. However, Mrs. B. Chaudhary, Learned Counsel, for respondent numbers 1, 2, 3, 7, 8, and 10 is present. Next para. The petitioner was unrepresented when the matter was previously listed and called on 4/8/2025 and 29/8/2025. And accordingly, this court by order dated 29/8/2025 recorded that if on the next date none appears for the petitioner on call, appropriate orders will be passed. Next para. As the
Lord, I have
Petitioner
one
is-
submission, but that this petition is not maintainable as because my lord,
unless you pay for any other order.
why I'm submitting, I'm appearing for 1, 2, 3, 7, 8, and 10, my lord. Because we have been illegally arraigned because the plaintiff, our petitioner in interest is alive, my lord, by the grace of God. He is alive, my lord. So his heirs, they have no locus standi now, my lord, because petitioner in interest is alive. We have been illegally arraigned as party respondents. So that may
Oh.
be recorded, my lord.
Oh.
1, 2, 3, 4, 5. They are registered in interest.
So this 1, 2, and 3.
1, 2, 3, 4, 5, my
4,
lord.
5, okay. Uh, Next paragraph. The learned counsel for the respondents has submitted by referring to the plaint of TS 15 of 1997 that the plaintiff number 1 in the said suit is Sri Sarat Burman, S-A-R-A-T, Sarat Burman. So it is submitted that the defendant number, the plaintiff number 1 is still alive, but by falsely indicating in the cause title that Sarat Burman is deceased, comma, he has been illegally substituted by the respondent numbers 1 to 5 by showing the respondent number 1 as wife of late Sarat Burman, the respondent number 2 as daughter of late Sarat Burman, respondent number 3 as son, 3, 4, and 5 as son of late Sarat Burman. It's like it's submitted that the predecessor interest is still alive. The plaintiff number 1 is still alive. And therefore, not only this not only the present revision is bad for non-joiner or necessary parties, but also bad for non-joiner, for misjoiner of the respondent numbers 1 to 5 as legal representative of a person who is still alive. To stop, we find force in the submission of this of the learned counsel for the petition for the respondent numbers for the appearing respondents. Respondents. Next paragraph, be that as it may. As the petitioners are absent on the third occasion, the revision stands dismissed for non-prosecution. That means now the suit will proceed.
Miller,
The suit will proceed now.
the ex parte decree was passed. They filed a petition under order 9/13, my lord, that was dismissed. They prepared in April, my lord, that was also dismissed. Against that, they have come, my lord. Decree has already.
It is already there. Accordingly, the appearing respondents are at liberty to produce the certified copy of the order before the court, before the consent court to bring the order to the notice of the said learned court.
I got that, my lord.
Okay.
Twenty-nine.
Matthew, your worship. Yeah, in this matter, your worship, service await upon restaurant number 5, your worship. Others are complete, worship.
Today we have filed the Wakalatnama for respondent number 5, Lordship.
All right. Services complete, your
This is ready, the service.
worship. HR has already received, worship.
Okay.
I am also appearing, Lordship, for respondent number 3, 4, and 7,
3, 4, and 7.
and also 5, Lordship.
Mr.
T. Google, your worship, on
T.
behalf of.
Gogoi, and counsel for the petitioner. Mr. Ms.
M. Bolu.
M. Barber, and counsel, and the appearance for respondent numbers 3, 4, 5, and 7, and submit that the Wakalatnama in respect of respondent number 5 has been filed today. That's why accordingly the matters ready as regards service, and the records of the tribunal records of the court below is received. Accordingly, this is the matter for hearing. The commission head of 2026.
Apply.
Item 31.
For suspension and there is a delay. And on last was 4/2/26. There was order passed by the court regarding Mr. Hussein Miller not receivable from two finger. That means it was up and he blind received that.
I'm sorry, I did not get it. Please repeat again.
Order number 4/2/26. Can you see? 4/2/26.
4 to 26, yes. 1 to 13 except 4 is present.
No.
Then
And he is to file a order for the respondent.
no, there's something wrong. In this case, there was an order to file so notice by way of newspaper publication. That you have not done. So the service on respondent for cannot be said to be complete.
Complete.
How?
Next equivalent 7/8/24 legal years of respondent for included. Can you see that? Now, official I have seen on subject to correction that they have skipped the notice. And now only without my liability is to file a Kolkata. 1 and 4/2/13.
No, you see the order of 7/8/2024 is directing the applicants to take steps for issuance of notice on the respondents by registered post with AD, as well as by usual process on the legal representatives of respondent 4 Lal Banu Khatun.
My lord.
Now, 1811 says due to paucity of time, matter could not be taken up. And next date 11/12, you say that you have taken steps. Our registry says you have not taken steps.
No,
You were again given time to take steps. Then the court on 1/8 says you publish the notice in the newspaper.
But in the meantime, I'm to take any excuse than authorized.
No, we don't know. These things are very crazy. You see, now this is an application for substitution,
Fine.
correct?
Fine.
Of respondent 4. Now look at the service report. You are appealing for all.
No, my lord, I am appearing for 1/5/13.
No, we are interested in 4, not on others.
My lord, 4, my lord, my earlier order, my lord, I will, my lord, see, earlier I appeared, but my lord, some time may be granted for filing the communication. If he, my lord, receive the all, my lord, so I will appear, my lord.
Look at this. Mr. Rashid, no, give it to Mr. Rashid. You see, our office note says the notice on 4/1/46 is received by the respondent number 4. Respondent number 4 is dead.
Well,
Then how can it be a good service?
now that the respondent for legally also respondent for will be.
Please read that note. It says the process service report says that number 4 received it. The dead man comes and receives your notice.
With regard to moving issue by usual process server recorded like also has been a receipt for the respondents stating that the notice of all the respondents 4/1/46 were received by the respondent 4.
Respondent number 4 is dead.
Respondent 4/6, not 4/46.
4/3.
4/6. 4 in this side and 6 is there. Separate. 4 right side and 6, 1/6 left side.
Oh, it's in the other page.
The
Other
same
order.
page is same unit, but line is separate. Below
Okay.
line.
So then it is complete. We'll proceed
Yes.
ex parte then.
my lord,
Just a moment.
some time may be granted for in the meantime, my lord, I communication and I will file the Okala. Sometime.
No, you file your wakata will take cognizance, but for that we can't adjourn. Because the matter is pending for
My lord,
quite some time.
my lord, for that may be given by the, in the
No,
meantime,
you file it in the meantime, we will not stop you from filing,
my lord,
but the service is complete, we'll have to proceed further.
further, my lord, I will appear, my lord, on behalf
It's
of
okay,
Pronamber.
we are not restraining you. You file your wakata, we'll take cognizance, but right now, we'll have to say that the
My lord.
service is complete and
My lord, in the meantime, I file the Okala.
definitely do it. Mr. A. Rashid, counsel for the petitioners, has referred to the office note dated 25/7/2025, indicating that as per the process service report, from a notice on all the respondent numbers 4(1) to 4(7) were received by respondent number 4 within bracket 6. Accordingly, the notice on respondent number, the legal representatives of the deceased respondent number 4 is duly served. On the present call for the said respondents, Mr. Kawa, Mr. Zaid Hussain, and counsel, was appearing for respondent numbers 1 and 5 to 13, submits that likelihood of his engagement for the said legal representatives of the deceased respondent number 4. Be that as it may, as the notice is duly served. Now, in this 298 days delay, what do you have to say, Mr.
Delay,
Hussain?
that, yes, sir. Delay 298 days.
Mr. Hussain, they have shown a cause for 298 days delay.
No.
They say that the death, they did not know about the death till 18/9/2023.
Only that is late. 298 days delay. 294 days delay. Very certain few different places and landing another place. The story here,
18/9/2023 and 18/9, 89, did I say? Oh. The learned counsel for the petitioner has submitted that the information about death of respondent number 4 was received on 18/9/2023, for which he has referred to the order dated 18/9/2023 passed by this court in IS Civil 1656 of 2023, where the learned counsel for the respondents had disclosed the death of respondent number 4. Full stop. Accordingly, as this application has been filed on 16/12/2023, the court is of the considered of despite objection made by the learned counsel for the respondents, this court is of the considered opinion that the applicants have been able to show good and sufficient cause which prevented them from filing the connected applications for substitution and setting as abatement on time. So accordingly, the delay of 298 days beyond the period of limitation in filing of the application for The connected applications is hereby condoned. This disposes of this application. Then we have 46. 46 is you not file any application for
Abatement.
setting aside abatement?
Where it is fine, fine, fine. I was searching that, it is, there should be there, otherwise how three petitions you got there. Millionaires, name, that is, I'm searching this one. Several petitions are everything there.
So we don't file an application.
Around there, 1658,
Hmm?
1658.
1358.
Also, 165, that is for 2 and 3. So I am coming, not. 44 million. I know 44. 44 million, 24.
44.
My God,
Actually, 44. 44, where is that?
I have filed copy.
Oh, actually.
It was filed on 21st of March 24. Alan, otherwise I will try.
It is there. 44 is application for setting aside abatement under order 22 rule 9. This is allowed in the same ground. Then it is 46. This is a petition for substitution under order 22 rule 4. This is allowed, disposed of. Now
45.
there are three more applications. What are they for? 1656.
1656, there is another, yes, there is another, question number 2 and 3 also expired, and for that notice of issue, and we have taken steps, but so my prayer, Lozina court may submit a report so that you are registering the submit a report regarding the
I am not getting you. Respond number 2 and 3 have died.
also died.
You have taken steps.
And notice of issue, and I have taken steps long back. There is a only it was 26/4/24. 24. And notice were issued, but by register probably. Yes. Only report from the registry regarding service get them to. Order is 26/4/24. And that is what the anybody will have taken step.
And what nature of application is this? Section 5 of the Limitation Act. You have not even given the names of the legal representative of number 2 and 3.
And then
Case to procedurally Kasamani, Manwara Begum and Palam Abigan in the party.
You're not getting you. You see, you said that 2 and 3 have died.
My lord,
You have filed an application under section 5.
my lord.
Where are the names of the legal representatives?
I'll see. Can you see while checking?
It's not there. This is the application.
Yeah, but I also
There is no names of the representatives when you file an application for controlling.
So what's happening? Question of file 23.
You say, pass separate orders, huh? 1656.
Second June.
This is this is a sheet and counsel for the petitioner. Sorry, applicants. This is an application under section 5 of the Limitation Act for controlling the delay of 81 days beyond the period of limitation in filing of petition for substitution and abatement. First off, it is noticed that neither in the cost title of this application and nor in the statements made in paragraph 1 to 5 of this application, comma, there is a disclosure of the names of legal representatives of respondent numbers 2 and 3. Just comma. The application appears to be defective. Next, we don't consider for the petition applicants, please for some time to obtain instructions. Then in IE Civil 1657. Orders could be passed in this application as the connected IE Civil 1656 of 2023 is found to be defective. So on the period made by the counsel for the applicant, the matter is done today. This one, the dates will be given later on. Give a date after. Last will be, give it after vacation. And 1658 is an application for setting aside abatement. Yeah, please go ahead. Here also same thing as 1656. The application does not disclose the name of legal representatives of the respondent numbers, deceased respondent numbers 2 and 3. And the names are also not found disclosed in the statements made in paragraph 1 to 6 of this application. So therefore, it appears that the matter of this application is defective. So on the period made by unconstant for the applicant, the matter is still adjourned today. I shall show the presence of Mr. Z. Hussain for the appearing respondents. This is the first case. He will appear for them.
I am not appear on behalf of respondent number 2 and 3 in the matter main.
It's okay. For others, your presence will be recorded.
My
In this subsequent case, I will file a one.
Copy of 17. Just a moment. 417. But, Mr. Rashid, please tell us why we should interfere with the order which is assailed. The trial court says that it is your suit and you did not reduce evidence from 6/3/16 to 4/4/17. Therefore, 4/4/17 your evidence is closed.
Only as per I have seen lot, but only one date will have either fixed for evidence.
No. You have not demonstrated from earlier orders. You have annexed orders from on 17/1 to 4/4. The order of the court is that since 6/3/2016, the case is fixed for PWs. And this order of 7/1 is relevant because on 7/1 it says that you are given a last chance. So last chance you have been given twice. Last chance on 7/1, last chance on 1/1/13/17.
Also medical application of having that so on the ground of evidence. On merit and not something else now.
So what is your petition?
Main petition, 148.
You see, this prescriptions which you have produced does not lend any credibility to your illness.
Why?
The reason is very simple. You are suffering from chest pain on the left side lower part. And for that, the doctor gives you the advice of chest X-ray. So that means you are nothing serious about it. You did not have any heart attack or something like that. The heart was functioning properly. You have just a chest pain on the left side, lower part.
That is a medical.
But then this is not a disease which will take you, to lead you an adjournment from justifying adjournment for a year.
This pain left side is lower part. That is the.
Yes, I've seen that chest pain, left side lower part.
Lower part.
The chest is the entire cage.
Entire case is here.
No, the entire cage. We call it cage. It's the entire cage. The heart is on the upper right.
Left side, upper side.
My lord, this is the application for submitting the learned counsel of the petitioner for the adjournment. Same cause of action, same cause of action. And
It is your
all
suit.
regular
It
date
is,
already mentioned.
you see, your suit of 2015 is till date.
Real date, the petition submitted. The 25/4/20.
আজি কোনোবা পৰা পক্ষৰ হাকিজন হৈ তাৰ বাবে হাজিব পৰা নাই গতিকে
All the petition, they are not booby.
And Mr. Rashid,
Well,
this suit itself would not be maintainable. You are asking for a judgment and decree that the order passed by the settlement officer is illegal. Order of settlement, as a settlement officer, you can't challenge it in the suit. The only way is to challenge it in the revenue court.
Merit period, I am not submitting now. Only now these are the intermediate parties, etc. Then one merit is come. Merit period,
And you are asking for a share in the paternal properties.
well,
And who is defendant number 4?
defendant number 4 here. Lal Manu.
Hmm? Defendant who is Kudus Ali. What is his relation with you? With the plaintiffs?
Plaintiff period, Ahmad. Defendant number 1. Is it? Yeah.
So you see, it was a partition case we filed before the settlement officer. And why would he not have jurisdiction to do it? Now you can only declare right title and interest, and that would be binding on the revenue authorities. But the suit to challenge the order of a settlement officer is barred under 154. Your suit itself is not maintainable. And we had to look into it because of a different reason. One of the defendants, one of the respondents, you have given the age of 106. So if that is 106, it is our duty to look into all these matters. And Mr. Hussain has sealed your fate. In earlier occasions, you said that defendant number 1 was ill. After 1 was examined, now you change the stand to the witnesses are ill. And now you have produced a medical certificate which shows that the respondent number 2 was ill. So your premises for taking adjournment is false. Look at your petition of 4-4, your witness was ill. Your plaintiff's evidence is not even 18-3 was not discharged. Order 18-3 is not discharged. Before that, your evidence of other witnesses could not have been led. They had your. Sorry, we are dismissing this revision. Document silo. There is only a prayer for upgrading item 47. So apart from that, we will not be able to take up any other matter.
Item number 23 on.
Let me complete this part.
No.
Let me complete this part. And this third reason, this suit you have structured.
On merit, I have that thing done through the sender.
No, it's okay, but you see, the fact is that we are not saying anything how your suit will be not maintainable. We are not deciding your fate of your suit under order 7 to 11. But you come to the prayer made in the suit. Judgment for declaring that you are entitled to 1/3 share. Now, once you seek 1/3 share, it will be necessary to have a partition, but this suit is not for partition. Then you say, second is that the judgment, what you call the order of the settlement officer is illegal, set aside. That means there is an admission to the fact that other respondents who have names have entered is only by virtue of their shares in inheritance. But then you make a prayer. No, it's okay. We are not deciding this. We are deciding that your application for adjournment. Incidental questions. Now in the prayer D, you say that cancel the names of defendant numbers 4 from the Chitta and Jamabandi over the share of the plaintiff. That means unless there is a partition, how do you know that this is your share? There is no statement here that
it was required to file partition, should have make partition of the land
Then-
property, but without that, they have filed other. There is one wrong advocate of the advocate.
no, that we don't know. Advocates,
Like,
we
of course,
don't comment anything on the lawyers. We always address them as learned counsel. So no comment against learned counsel.
on that way, I'm not blaming, but I don't always comes from the asking.
But then now you see your defense fails. Your plaint fails because you say somewhere in your plaint that the others have relinquished their share. Relinquishment of a property will be covered by 17(1)(b). If it is 17(1)(b), it has to be compulsory registered.
And I want to say the property is also not used. Some gas.
No. Therefore, adjournment would not be maintainable. What to say, Rashid Lamet, counsel for the this is in CRP, counsel for the petitioners, next, as uh, it may be mentioned that three applications for respectively for continuing the delay, setting aside abatement, and application for substitution being in respect of respondent numbers 2 and 3 respectively registered as IA civil 650
1656, 1657, and
no, just 165 1656 for the continuing delay, 1657 being an application under Order 22 Rule 3 for substitution, and IA Civil 1658 of 2023 for setting aside abatement in respect of respondents 2 and 3 are pending. Full stop. As the court takes cognizance of the fact that by virtue of this revision filed under Article 227 of the Constitution of India, the order which has been the order dated 4/4/2017 passed by the London Municip number 1, Gwalpara in TS number 40 of 2015 has been challenged. So by the said order, the petition for adjournment filed by the petitioners seeking more time to adduce to examine further plaintiff's witnesses was rejected, and on closure of the evidence of the plaintiff's of the petitioner's side, the case was fixed for defendant's evidence. Next one. The learned counsel for the petitioners has submitted that as the petitioners are seeking right title and interest in respect of the suit land and also for recovery of caste position, if the evidence of the petitioners is not permitted to be recorded, they would suffer irreparable loss and injury. Next para. Mr. Z. Ahmed, learned counsel for the appearing respondent numbers. You are for respondent numbers. You take it from that first order.
1, 5 to 13.
1,
1, 5 to 13.
1 and 5 to 13 has submitted that as per the impugn order dated 4/4/2017, the case was pending for evidence since 6/3/2016. And despite several opportunities, petitioners have availed more than the permissible adjournments, more than adjournments that are permissible under Order 17 Rule 1 of the CPC. Next para. On the perusal of the materials available on record, it is noticed that in that as per the orders, as per a few orders annexed, the order dated impugn order dated 4/4/2017 discloses that as per the case records, the case is pending for PWs since 6/3/2016. So the other orders, specifically order dated 7/1/2017, discloses that the PW1 was cross-examined and discharged, and the case was fixed on 1/3/2017. So, on the said date, while granting adjournment, the learned trial court had recorded that the petitioners side, within bracket, plaintiffs were given last chance to adduce evidence, and it was ordered that in the event, it was ordered that it was ordered accordingly. So, however, again on 4/4/2017, a prayer for adjournment was made, and the learned court rejected the same, and the evidence of the plaintiff's side was closed. Next, for the learned counsel for the petitioner has referred to a medical certificate dated 25/2/2017, which is in respect of the plaintiff number 2. To stop in the as per the plaint, there are as many as 4 plaintiffs. But as per the
whatever for improvement or my, that should be there, otherwise they will think it is personal. Otherwise they will think, actually it is, I have a case, maybe it is our fault, not I have. Master.
My lord, claim the evidence of the method is allowed the PW to evidence. No, my lord, I am obliged. No, my
Yes, then, I have also been instruction on that point. And if some after some days, Milan, we have to file, if the case is serving here, Milan, you have to file another certificate. One is 6 years Milan old, so. Yes, now maybe in last 10 years, case is running more than 10 years.
My lord, I am in deep trouble in this case. My lord, it was a case was dismissed for default, RSA, during the course of hearing. I was. Lordship, last I am communicating my feelings. One time, Lordship. Now, my lord, once we have taken step upon in the condonation petition, then said that address is left without instruction. Then, from my client, Harisharan Das, I collected the appropriate address, correct and full address. We sent notice. This time, my lord, report has come that address is insufficient. In the meantime, my lord, no. No, latest one we have sent as Jadhav Daka, son of Lohit Daka, resident of village Vidyapur. He has shifted. No, only postal, not in the record of the case, but in the what section third, it said that you just give in the envelope, we will send it. Yes, correct address was given. Postal department. That address has been returned. That in the return memo it is there. Jadhav Daka, son of Lohit Daka, resident of village Vidyapur, ward number 3, bylaw number 9. Lordship. It is his another address. Now he has shifted from earlier address. Okay. I will bring, but my lord, in the meantime, that execution proceeding, my lord. But in the execution proceedings, that earlier address is going on still. They have sent communicated notice in earlier address. No, Lordship, okay. No, I am not seeking stay, my lord. We will bring the routine in record. May be allowed to be corrected. Which is fixed on 17/6. By Monday we will take. By Monday we will take. Then six, I don't want, on Friday, on next Friday. Friday কোথাও? Lordship,
Tuesday, Lordship. Order 23,
এখানে correct না
order
করে
41 through 11 hearing. 21. Wednesday, Lordship. 23. no? Lordship. Wednesday, Lordship. Wednesday. Obliged.
Lordship, item 41 may also be fixed on 18th Wednesday. 41 from Delhi list. ML Pandya Lordship. Forty-one. Yes, Lordship. Yes, Lordship, for now. Steps were already taken. Much obliged.